Okay. Good morning and welcome, everyone. This is the sixth day of evidentiary hearings for the SouthCoast Wind Energy LLC Brayton Point project, EFSB 22-04 and DPU 22-67 and 22-68. My name is Robert Shea. I am the presiding officer in this proceeding, and I am conducting today's evidentiary hearings. As part of the bench today, there are other members of the Siting Board staff. Andrew Green, the director of the Siting Board, Wayne Wong, the assistant director of the Siting Board, and Smitha Devakar, a Siting Board analyst. Please note that this hearing is being recorded by our stenographer, and video recordings will be posted to the Siting Board's YouTube channel for viewing. May I have appearances of counsel, please?
Yes, good morning, Mr. Shea and all. Eric Runge for SouthCoast Wind Energy LLC with the law firm of Dave Pitney, office in Boston.
Thank you, Mr. Runge.
Good morning, Mr. Shea. This is Margaret Seepiel, also from the law firm Dave Pitney, address of 555 11th Street Northwest in Washington, D.C.
Thank you, Ms. Seepiel.
And good morning, this is George Pucci from KP Law in Boston for the intervener town of Somerset.
Thank you, Mr. Pucci. Before we begin the hearing, I'd like to address some procedural matters. The town's motion to stay the proceedings is still under advisement, and we will not be making a ruling on that motion today, but it is under advisement. But I would like to make a ruling on the company's motion to strike the Somerset Zoning Board of Appeals letter dated May 1, 2023, because we'll be possibly examining people on that, and I want to make the ruling first. Exhibit A to the testimony of Tim Turner is a letter from the Somerset Zoning Board of Appeals to Mark Alucci, the Somerset Town Administrator, dated May 1, 2023. In the letter, the Somerset Zoning Board of Appeals states that it unanimously voted to oppose the waiver or exemption of any of the town's zoning bylaws as requested by the company in its zoning petition. The letter also contains numerous allegations regarding the company's zoning requests, such as that the company never reached out to the Zoning Board of Appeals requesting, quote, time to present their project, close quotes, as they are required to do. Let me just take a break. I can close the windows. Can anyone hear that dog yapping?
I can't.
Okay, all right, it's then good. Then I can hear it, but if you can't hear it, that's fine. So that the company never reached out to the ZBA requesting time to present their project as, quote, they are required to do, close quotes. That the company has, quote, failed and refused to attempt to resolve potential zoning issues at the local level, close quotes. That contrary to representations made in the zoning petition, the company does not need an exemption from the following regulations of the Somerset zoning bylaws, which including various use regulations, minimum setback requirements, planned development, parking and loading requirements, noise, and floodplain overlay district. No members of the Zoning Board of Appeals have appeared to answer questions regarding this document. The company has moved to strike the ZBA letter based on its lack of probative value. Mr. Pucci, counsel for the town, asserts that the letter would be admissible in a court of law pursuant to Massachusetts rules of evidence under the public document exception to the hearsay rule. The admissibility of authenticated records of governmental departments is governed by statute, General Laws, Chapter 233, Section 76. This statute provides that, quote, copies of books, papers, documents, and records in any department of the Commonwealth or of any city or town, authenticated by attestation of the officer who has charge of the same, shall be competent evidence in all cases equally with the originals thereof, close quotes. And while the EFSB and the DPU are not bound by Massachusetts rules of evidence, those rules are very instructive, and the Siting Board and department follow them when practicable. So I did some research, and the Massachusetts case law addresses the limitations of the public records exception, the public records statute, admitting public records and proceedings. The case law provides that records of fact in a public record are admissible, but representations of opinion are not. And I'll cite to the two cases I'm relying on: Julian versus Randazzo, 380 Massachusetts 391, decided in 1980, and it's an SJC case, and then a Massachusetts Court of Appeals case, Mattoon, Mattoon versus City of Pittsfield, 56 Mass Appellate Court 124, and it's a 2002 case. So under these circumstances, it seems best to admit the letter into evidence subject to the following restrictions. One, those statements in the letter that contain purely factual information, for example, that the Zoning Board of Appeals has voted to oppose granting exemptions to the company. Those purely factual information are admitted into evidence. But the statements of opinion in the letter won't be accorded any evidentiary value. I don't think this will prejudice the town, because any statements of opinion that were made in this letter can be reiterated in the town's brief. And this ruling does preserve the fact/opinion distinction regarding admissibility of governmental record evidence that's been articulated in the two cases I cited, Julian versus Randazzo and Mattoon versus the City of Pittsburgh. Does anyone have a question about that ruling? Okay.
I do not.
Okay, thank you, Mr. Pucci. Next, I'd like to address the issue raised in record request RR-EFSB-29. I believe that in that record request, Mr. Green asked the town to articulate what conditions it would like if the site would like the citing board to impose on the company in the final decision, if the final decision grants a zoning exemption. And based on email correspondence I received on Friday, August 4th, I believe the town does not have an answer to this record request. Is that correct, Mr. Pucci?
At this time, I do not. Yes, that's correct. I would be seeking an extension.
Okay. In that case, then I'll posit another record request, but this one addressed to the company. I would like the company to reply to the town's response to RR-EFSB-29. Specifically, I would like the company to explain the extent to which it would be able to comply with the town's requests without undue hardship. So RR-EFSB-29 is the town stating what conditions it would like the citing board to impose on the company in a final decision, if the final decision grants a zoning exemption. And then this last record request would be a response to the town's conditions from the company. And I'll ask Mr. Brock for a second for which this last record request, which one that would be. That's RR-EFSB-36. All right. Does anyone have any questions about those?
I have a question. Eric Runge for the company. My question is the timing of this. So obviously the company can't respond until it sees what the town has produced. I assume we have 7 days from when they produce something. Is that correct?
Yes, you do. And let me ask Mr. Pucci about the record request responses. Do you have an idea of when you can get the responses in?
Yes, so I have two categories in addition to the one that you noted. The other one is, I forget what number it is, but it was something along the lines of identify all of the local regulations applicable to the project, you know, that we would like to have apply, irrespective of your ruling on the zoning exemption. And so I lumped that one in with this number 29. That one, those two I would appreciate an extension to. The other bucket of requests, we can definitely get those out this week. So I would be seeking an extension to Friday for anything but 29 and 30. And then I would ask until August 25th on 29 and 30. the reason I asked for the somewhat lengthy extension, although it is certainly this month, I can't answer those on my own, and I can't use only one witness to answer them. It involves potential follow-up with different boards of the town, different agents, town administrator, possibly even the Board of Selectmen. And these are all boards subject to the open meeting law, so I can't just make a phone call and get answers to these types of questions. And I'll certainly use, town witnesses who have testified to the extent I can, such as Tim Turner and Nicole McDonald, people like that.
Yeah.
But I would feel more comfortable in good faith just asking until the 25th for those two requests.
Okay, let me ask you, you said 29 and 30. Did you mean to include 36 in that? 36 is the one I just asked.
No, that's the company.
Well, that's the company's one. So 30 was the one about the conditions that you'd want to impose.
No, 29 is that.
Okay,
In the event, Mr. Green had asked if the board granted the zoning exemptions, what conditions would the board, would the town be seeking? And then there's another one, number 30, I believe it is,
right.
which asks more, basically everything in local regulations and bylaws that we would want to have applied to the project.
Okay, so you'd like an extension to August 25th. Let me hear what Mr. Runge has to say about that.
I'd say that we object to that. There has already been a lot of delay sought by the town in this proceeding. They sought to dismiss and stay the proceeding. They threatened to extend the hearing dates by filing a motion. And this response should have been something that the town has been thinking about for a while. And I'm surprised that they didn't have the response in place, filed on Thursday when it was due. Mr. Alucci is a witness today, and they knew that he would be here. I plan to ask him questions about the conditions. Now I don't have that, so I think that the company has been impeded in its right to question the witness for the town. That seems unfair to the applicant and contrary to good procedure. So I think that they really should get the response in as soon as possible and not further delay the proceeding.
I have a reply to that.
Go ahead, sir.
And I'm going to try to be polite about my reply. First of all, Mr. Alucci is here today on our agreement on the siting board's request to come here and testify further to the zoning board letter. That's been the subject of last week's proceeding. He is not here for counsel for the proponent to re-ask the questions that they had the opportunity to ask the town witnesses on. If I wanted him to testify on those issues, I would have pre-filed testimony. He is being produced today for a limited purpose, only pursuant to the siting board's request. And as to the statement that the town should know the answers to those record requests before we came into this proceeding, I find it politely, that's a nonsensical claim. Where I would want to make the town's position on those issues known would typically be in post-hearing briefing that I anticipated filing with the siting board. I'm obviously not coming into these proceedings with my post-hearing briefing finalized, but that would typically be where I would sit down with everything and figure it out, having conferred with our witnesses, having the whole evidentiary record, and then I would make the case about what should apply. I'm not coming in anticipating that there may have been record requests generated during the testimony. And those questions go more to issues that would be addressed in post-trial briefing, which are entirely appropriate to give me a reasonable extension to August 25.
All right, Mr. Runge, do you have anything to say?
I'm not going to argue the timing of when this is due. I think you've already heard my argument for that.
Okay.
But I will note that I do intend to ask Mr. Alucci some questions beyond just this letter to the zoning board. So we should probably get clear on what the scope of questioning is for today.
Okay. Mr. Pucci, you said that you produced Mr. Alucci just in respect to the zoning board of appeals letter.
Correct. And I had Mr. Ulucci spend a lot of time last week preparing for this so that he would come in and not say, I don't know, to every single one of your questions. So he's done a full electronic search of any and all communications with SouthCoast Wind, with the town boards. He reconstructed in his mind the entire timeline that went down since he became town administrator in the town. He also discussed with me in detail attorney-client privilege issues and my agreement to waive attorney-client privilege with regard to that anticipated testimony. I also produced Ms. Sousa again in response to the siting board's request because she was an associate member of the zoning board at the time that the zoning board had the meeting, which ended up resulting in that letter. So these witnesses have spent time preparing for the proceeding today. Had I been told that the town administrator would be possibly testifying on conditions to go on a siting board decision, I would have objected to that. He is not the witness to testify on those issues.
Tell me, why is he not the witness to testify?
He's the town administrator. He's a administrator for the town that serves as a liaison to the Board of Selectmen, which is the executive authority. He oversees many town departments, various business of the town, including labor issues, the gamut of what a town would involve. He's not a permitting board liaison. He's not a zoning administrator or a town planner or anything like that. And he's not, he never requested that he speak on behalf of the town in terms of conditioning a possible siting board decision in this. It's not within his expertise, and he had absolutely no preparation on that issue at all. It would be totally unfair. I would have pre-filed testimony if he had testimony to offer on those issues.
Okay, but I understand, for example, if Mr. Runge says, oh, what's the selectman's position on this, that, or the other thing? Mr. Ulucci can say, I'm not on the board of selectmen. I don't know. So
I mean, we could take them question by question, but I'm just advising in advance. You may hear a lot of objections depending on the scope of the questions of the town administrator.
I appreciate that. So we've got two matters. We have the extension. I take it, is there any objection to an extension on the response to record requests, the town's response to record requests, to the end of the week for everything except 29 and 30? Mr. Runge?
Not for the other ones except 29 and 30. And I would suggest have it the end of the week for everything.
Okay. What I'd like to do is, because it would be a major ruling, would be we're going to start with some questions, and when we have a break, which we usually have a morning break, I'd like to consult with the other members of my team on the extension to 8/29. And I think we might take the questions to Mr. Ulucci, Mr. Runge's question by question, because Mr. Ulucci is someone with knowledge, but as you say, Mr. Pucci, he doesn't speak on behalf of the zoning board, so his testimony may be of limited value, but I'm inclined at this point to take it question by question, and of course you're free to object to anything that you think is improper.
And by the way, it was the 25th, Mr. Presiding Officer, that I requested.
What do you think?
It was the 25th, not the 29th, and the 25th is the full week in August before the week that goes into the end of August and into Labor Day weekend. So,
right,
25th.
And I understand, and the reason is that you have to consult with various boards that are subject to the open meeting law, and you can't just pick up the phone and ask someone what they think.
Correct. Some people I can pick up the phone and ask them what they think, but as I'm going through it, I may need to consult with boards on particular issues. I may need to consult with the executive authority for the town in terms of what the position we're taking. I mean, essentially, I'm being asked to provide the town's post-trial brief, within 7 days. I didn't object to the original record request because they were generated by the siting board. I'm trying to participate in these proceedings in good faith. And I would err on the side of not objecting to anything requested from the citing board, but I would like a reasonable time to be able to reply to it. It's essentially my post-trial brief.
Okay, and let me ask Mr. Runge, do you understand Mr. Pucci's situation in that if he says, well, these are the conditions, and he lays out a bunch of conditions, these are the conditions we'd like to see, it would be very awkward for him if a member of the citing board were to call him up and say, these aren't my conditions. I don't agree to these. How come you didn't talk to me? My point is that Mr. Pucci has to consult with a lot of people to get a consensus on what conditions would be appropriate for the town.
So in response, Mr. Shea, I do somewhat understand the need to consult. Obviously, I have clients that I have to consult with too, and lawyers don't just make up stuff and put it on paper and send it in. However, it seems to me that Mr. Pucci hasn't even begun the consultation process, and I don't think you should reward any kind of slackness in that now by giving him further extension. That's my point.
All right, well, what I'll do is during our break, I'll consult with the members of our team, because we generally, as a general rule, when something is a significant motion and it could really impact the proceedings, we consult and we talk about it, and it's that type of a process. So thank you very much for your arguments. You're both quite articulate in what you in your positions. Regarding the exhibit list, I'll request that the company update the exhibit list once all the record responses have been received. Is that okay, Mr. Runge?
It is.
Okay, thank you. Now, I've got some questions that I've got to ask of Mr. Runge directly. And you can call on, I believe all your witnesses except Ms. Earhart have been sworn.
Would you like me to announce the witnesses for today, sir?
Oh, why don't you announce the witnesses for today? Thank you.
I'll do that. So today we have either here in the room with me or remotely, Kathleen Freeman, Jennifer Flood, Kelly Smith, Kelsey Perry, Tim Ryer, Sam Ashe, I believe, is on, Vic Mastone, Jamie Durand, Andrea Wood, and we have one new witness who will need to be sworn. That's Jennifer Earhart.
Okay. All right. Why don't I swear Ms. Earhart right now, because I've got questions primarily for you, Mr. Runge, but you may want to call on your witnesses. So Ms. Earhart, will you raise your right hand and repeat after me? Or not repeat, but respond. Do you solemnly swear that the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, let the record reflect that Ms. Earhart has been sworn. Now, the questions I have for Mr. Runge, okay, I direct your attention to a pleading that you filed in entitled the SouthCoast Wind Energy LLC response in opposition to the town of Somerset's motion to stay proceedings. It's dated July 12th of this year. I'll give you a chance to take a look at it. I'm specifically looking at pages 7 and 8.
Okay. Margaret, if you have that, can you email it to me? All right, let's see. What page was that again, Mr. Shea?
7 and 8, Mr. Runge.
7 and 8. Okay.
The indicators of progress.
Yes.
Okay, I want to make sure that these indicators of progress are on the record.
Okay, I can just to help you there. We did put these on the record, and I believe they are in supplement 1 to EFSB 4, and Margaret, correct me if I'm wrong on that. Sorry, we couldn't hear you, Margaret.
Sorry, I was just saying that is correct. Yeah.
Okay, that's very helpful. So all these indicators of progress are in the response to the supplemental response to EFSB-N-4.
And if I might, just on that one, we did try to put a lot in that N-4 supplement, just so you would have it all in one place, I think as requested by Mr. Wang a while ago. So you'll find a whole bunch of stuff in there.
All right, that's very helpful because that could be an important part of the decision. I appreciate that. Why now I would like to swear Mr. Alucci, the new witness for the town. Mr. Alucci, I'm just looking, I'm scanning for you. There you are, sir, in the blue shirt. Would you please raise your right hand? Oh, you have to turn off, you're muted right now. Ah, there, that's better. Thank you, Mr. Alucci. Please raise your right hand. Do you swear that the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, let the record reflect that Mr. Alucci has been sworn. Let's go through my notes here. All right, Mr. Pucci, do you have any direct examination for Mr. Alucci?
I do not.
Okay, then I've got some questions for Mr. Alucci. I'd like to start with those. Mr.
And
Alucci,
Mr. Shea, I did just want to note to you for your questions. I did advise Mr. Alucci that we're waiving attorney-client privilege with regard to his communications with me concerning when the ZBA letter was generated and, history leading up to and after that. But
Okay.
beyond that, we're not waiving attorney-client privilege.
well, I appreciate that, and I appreciate you getting that on the record. Thank you very much. Let me ascertain. I believe Mr. Alucci is just available for this morning. Is that correct?
I believe so, yes. And Ms.
Okay.
Sousa as well is here on the same topic.
Yes. Thank you. And Ms. Sousa, you've already been sworn, so you're still under oath.
That's correct.
Yes. Mr. Alucci, would you please explain your role as town administrator?
Yes, sir. So as the town administrator, I'm a liaison to the Board of Selectmen. They are part-time employees for the town, elected by the town to represent the local government. In this capacity, under the Special Act of 1984 here in Somerset, I'm tasked with the day-to-day duties of the town that include being the representative as the personnel director, negotiating contracts.
I'm sorry, that include being a what?
Personnel director, preparing a budget annually for the town, contracts to do construction and things of that nature, and as indicated, the day-to-day for the town.
Okay. And what was your role in particular in dealing with SouthCoast Wind?
SouthCoast Wind, Mayflower at the time reached out to me in October explaining, October of 2022, explaining that they wanted to come in and essentially be a plug to the cable that would be taking place off the coast here, part of a larger wind project. And they wanted to, I met with their personnel, or I was contacted by their PR, their public relations personnel, Kelsey Perry, and she wanted to set up dates and times that she would like to inform the town on what it is that's coming to Somerset, or what they hope to have come to Somerset.
Okay, and I'm sorry, what was the date that you said that happened?
That was in October of 2022.
Okay, thank you. Did you ever tell anyone from SouthCoast Wind that the company and its representatives should deal directly with you?
For their PR, for their public relations to the town, yes, I would help them set up meetings where they could inform the town.
Okay. Did you ever communicate that you were the exclusive person with whom the company should communicate?
For everything?
Yes.
Not for everything, no.
Okay. Did you believe that you made that clear, the distinction between what you should be contacted about and what you shouldn't be?
Yes,
And in your role as town administrator, are you authorized to speak on behalf of the town?
yes.
Okay, how are you authorized? Is there a bylaw regulation?
Yeah, that's the Special Act of 1984. Yes, sir.
Okay. Did you ever tell, and pardon me, this is slightly repetitive of a previous question, but did you ever tell anyone from South Coast Wind not to deal with other town officials?
Not that I recall. Like Board of Selectmen?
Board of Selectmen or zoning board?
No. As a matter of fact, there were two representatives in the town that we met with them, South Coast, and we had someone from planning and our ZBA inspector who works for the board, the ZBA board, and both of those employees told during that meeting what they would have. The process was to go before planning and zoning.
Okay, can you tell me who those employees were?
Yes, Tim Turner, who's on the planning board, and Rick Forehand, which is our building inspector who works in conjunction with the ZBA.
Rick Forehand works with the ZBA. Do you know if the company communicated with Mr. Turner, Mr. Forehand after they met?
Yes, I do. I received an email in November from Miss Perry stating that she had met with both Rick and Tim about planning and zoning requirements and bylaw requirements, and she indicated in the email that she understood the requirements.
Okay, that's helpful. Thank you. And tell me, do you remember roughly when this meeting was with Tim Turner and Rick Forehand?
I think their initial one, I want to say, was around November 2nd. And then we had another one with those individuals also present on April 10th, which was a follow-up to what they would have to do for planning and zoning.
Okay, so that'd be November 2nd, 2022 and April 10th, 2023.
Yes,
correct?
Correct. I was not present for the November 2nd one, sir.
Okay, but you were present for the April 10th meeting?
Yes.
Can you summarize the communications at that meeting?
The one on April 10th?
Yes, please.
Yes, so that they wanted to come down and talk to department heads, and they wanted to express why they wanted to be exempt from our bylaws, and which is always difficult because you have the town sets up these bylaws and they have these committees because they want to protect the town, and we would anticipate any business or company coming in would follow those. They wanted to express to a lot of the department heads why it was they were seeking exemptions. So during that meeting, both Tim and Rick, I believe, were both present, and they went point by point on why they felt, well, we don't need to go before zoning because we feel we meet this requirement, or we don't need to go before this committee, or we meet this bylaw, so we're seeking this exemption through the EFSB. So it was kind of explaining why they wanted to bypass our boards and our bylaws to go before your board, sir.
Okay, and was there response from Rick Forehand and Tim Turner?
Well, I think the response was, people will be upset because we have these laws, these bylaws where you're required to go before them, and you're looking for kind of, I don't want to use the term, end around. I understand that in this process, there are paths that this facility can take that, the average company doesn't. But I would say that they weren't overly pleased about it.
Okay. Did the company, I'm sorry, yeah, did you ever ask the company for something, some specific information, for example?
Yes, they supplied, during that meeting, they had kind of like a punch list of, well, here's why, we're not required to go, before your zoning, and here's why we know we'll meet the decibel level. So your sound, the sound's not an issue for us. So there was kind of, a list of items that on why they wanted to go outside of our committees and bylaw.
And did the company ever fail to provide something that you asked for?
Well, yes, I mean, I asked for, we had been trying to set up a host community agreement, and I had asked for an outline of that agreement, and I also asked for agreements they have with other companies that HCAs that they've had. They indicated that they don't have any other host community agreements, that they couldn't supply me with anything there. And when we asked for the extension to before the board, because we had all these things that they wanted to negotiate, what that can include in the host community agreement. If they're going before the board and seeking these exemptions, a lot of those things are written out in the HCA, and we didn't have any of that. So I didn't want to go before the board without some type of draft, and we were up against deadlines on, if we're going to the board, we have to meet these deadlines to get this material in. So I did not get what I wanted from them when it came to the meeting up on the HCA and negotiating kind of a rough draft of what we're looking at for the town.
Now, don't let me put words in your mouth, but I'm going to try to characterize this. Were you looking for something like a term sheet?
Oh, yes, sir. Yep.
Okay, so these are the terms that we want, but it's not a final product, excuse me. All right, and did you ever, I think you've already answered this, but I have to ask the question, did you ever get the term sheet?
I believe I received an email from them, from attorney Dan Hubbard, that was talking about some of the terms, but he had indicated that he had to go before his board, which is why we wanted the extension. He gave us 2 weeks, and then he never met before his board. So I apologize. I can't recall specifically. I know we're starting to get into that, but that's something that we're going back and forth now on these term sheets. So I don't believe I got the terms earlier on in any type of written structure.
Can you tell me if you know where the company and the town are on an HCA? I mean, how much of the pardon me, how much have the negotiations progressed?
Well, not much, sir. And I apologize. I just want to be able to give a little bit of background. I want the whole board to understand. The communication for the HCA started months ago, and it seemed, and South Coast has very, very nice people. Kelsey and her team are very nice. But as we moved up to get closer to these dates, they didn't want to meet because they said they still had to go before their board. So what I couldn't figure out was why grant a 2-week extension if you don't meet with your board within those 2 weeks, and we still don't have the ability to go before the HCA. So they only wanted to give us 2 weeks, but it seems counterproductive. It would be, let's have an extension where you can meet with your board, learn the parameters of what you're allowed to negotiate within, and then if we have an HCA hammered out, we may not have to go before the board for all these different requirements and exemptions. So it was very frustrating because it wasn't until we got to this point where we submitted all our things before the board and had to meet certain deadlines that now, they've kind of reached out and said, hey, Mark, we want to have a meeting. Maybe I received an email last Friday. I believe it was last Friday, just before the weekend, saying, hey, can we talk about some of the terms coming up, I believe this Friday, or around the 10th. So to me, this stuff should have been done months ago, and now they're only being done now. And I can't help but think it's because of, we're before the board and we're, things are becoming difficult maybe on all sides, and they're trying to get the HCA, dealt with.
Tell me about this 2-week extension. I'm just not clear on who asked an extension of whom.
Yes. So when we talked about the host community agreement, I asked for them. I said, look, can we please have an extension, because we haven't hammered out the HCA. We haven't even done a draft. We've done nothing with it. And they indicated they were on a very tight deadline, that they would only be able to agree to 2 weeks. And at the time, that may have been enough to hammer out, because it was a couple months ago, I believe, that may have been enough time to come up with an agreement. However, it didn't. And on top of that, as the days got closer, or these dates got closer, I said, you agreed to a 2-week extension, but you still won't meet on the HCA. Why? That became, well, we have to go before our board, Mark, and I need to find out what the terms are. What are the parameters we can operate in with negotiating? And when I asked about that date was after the 2 weeks. And I expressed that to Mr. Hubbard and to SouthCoast in general, that, it was very frustrating that you agreed to a 2-week extension, but now you're telling us you can't meet with the people who will give you direction on the agreement until after those 2 weeks. So what was the point of giving us 2 weeks to work on, more time to work on an HCA, if you still hadn't met with their board? And then after those 2 weeks, that 2-week extension, it was after that in July, late July, that they finally met with their board and said, hey, Mark, now I know the parameters of what we can negotiate for, and I'd like to sit down and go over those with you. And that's where we are now, sir.
Okay, so I want to make sure I get this clear. You believe it was late July that the representatives of the company that you've been dealing with met with their board of directors?
Yes, sir.
Okay. And did you ever meet with the Board of Selectmen regarding an HCA?
Yes, sir.
And when did that happen?
I believe it was several months ago. I believe it had been on a couple executive sessions because they were looking for updates. And that's how I had first approached them with some of the requests that the town was making from the board. And I had shared those with Mr. Hubbard and SouthCoast, and they were like, well, we have to go before our board, Mark, before we can even comment on any of that stuff you've thrown at us.
And so this communication about as you say, the stuff you've thrown at us, what you got from the board, when did you communicate what the board wanted to the representatives of SouthCoast?
It was probably like within a day or two after the executive session. I would circle back immediately with Mr. Hubbard and just kind of read him in on everything that was discussed from the negotiation style.
Okay, the executive session, did that taken place? Do you remember what month it took place in?
There have definitely been a few. I would say probably around March or April.
Okay, so your best memory, and I realize you don't have documents in front of you, is that you communicated at least some aspects of what the town wanted to the company around March or April of this year. Yes,
yeah, I would. April, May, I would. Yes, that is correct.
Okay, March, April, May, that time period. Thank you.
Yes,
now, sometimes I have to ask questions, even though it may seem like I know the answer, but would you describe the company as cooperative in your dealings, or uncooperative, or someplace in between?
I'll break that into two parts, sir, if you'll allow me to. I think their PR staff has been very cooperative. They're great. When they want to set up appointments and say, hey, we're going to do something at the Fairfield Inn, they're open to dates, times. They want to work with us in getting the word out. Where they have been exceedingly difficult is this point in time, trying to work on an HCA or trying to work on an agreement with the town and the company prior to anything before the EFSB. And I personally, sir, I feel as though okay, if they get in front of the EFSB and these things are passed, then they have leverage over the town on what they'll agree to in a host community agreement. Why else hold everything up for months when, you know, the way when I research it, a lot of these programs have passed.
Now, you've mentioned that a couple of times you communicated with the I'm sorry, the select board, excuse me, in executive session. Is that correct?
Yes, sir.
Did you ever communicate directly with the zoning board of appeals?
The only communication I had was with the chair, Mr. Cataract.
And tell me about that communication.
So when I had informed both the chair of the ZBA that, you know, they don't want to go before your board, SouthCoast doesn't want to go before your board, they're looking for exemptions, that's why they're going to the ESFB. I asked for a letter from him that we could submit to some of these upcoming dates to the ESFB, and that's how we had gotten that reply.
And that's how you got the May 1st letter?
That is correct, sir.
All right. Yeah, I'd like to ask you some questions about the May 1st letter. When did you first see the letter?
The first time I saw the letter was when it was emailed, and I don't recall. It was probably that first week of May.
All right. Were you present at the April 20th meeting of the ZBA that's referred to in the letter?
No, I was not.
Now, in the letter, I'll just quote something. It says on the second page, the petitioner never contacted the zoning board of appeals and requested time to present their project. Is that true to the best of your understanding?
Yes.
Okay, and thereafter, the letter states that this they were required to do. Do you understand why the ZBA says that the company was required to contact it?
Well, when you're seeking any exemption under zoning, under the bylaw, you're required to go before the zoning board.
Now,
Mr. Shea,
sir, yes.
I am being very good about not testifying for the witness or interjecting anything, but I did just want to note the zoning petition had been provided to the zoning board at some point prior, because I don't know if Mr. Ulucci understood your question to include, you know, anything in writing that was provided to the board in addition to any direct communication he had with any of them by word of mouth. And they were provided a copy of the zoning petition, which I know was also a subject of their discussion at that April meeting that they had. That's on videotape, by the way, if anyone wants to see it, their meeting on that. So that Mr. Ulucci had produced the zoning petition to them by email, I believe, which is, you know, another thing that you know, led them to putting that agenda item on in April.
Oh, thank you. So, Mr. Ulucci, you provided thank you, Mr. Pucci. You provided the zoning petition to the zoning board of appeals. Do I understand that correctly?
Yes.
And about what time did you provide that?
I think it was the first week of April.
Did you have any conversations with zoning board of appeal members regarding the zoning exemption petition?
No, not directly, not that I can recall.
Thank you. I'm going to address your attention to section 2 of the letter. Do you have the letter in front of you?
Yes, I do, sir.
Thank you. The section 2 of the letter states the headline is Mayflower Wind has misstated the town's zoning regulations. Have you read this section of the letter?
Yes, sir.
All right. And are you generally familiar with the zoning bylaws in Somerset?
Not an expert, sir.
Okay. the first A2 is use regulations. The zoning board of appeals makes a argument about the substantially similar nature of the proposed use to an allowed use. Do you understand their argument?
I'm sorry, sir. Can you say that question again, please?
Yeah, do you understand what the zoning board of appeals is saying here? Do you understand their argument about substantial similarity?
Well, it sounds like the petitioner is attempting to or construct something that the zoning board believes, meets a similar definition of their purview when it comes to that station.
I'm wondering, are you aware of this doctrine, substantially similar, being used by the zoning board of appeals before now?
I'm not aware. I don't know that. It's possible.
Regarding the minimum setback except requirements, the letter says that the need for this exemption is based, quote, solely upon speculation and without any factual basis. Do you understand the reasons behind this statement by the ZBA?
No, because I'm not sure what they're referring. I don't know what they're referencing as the setback, so I don't know at this point what the zoning board is specifically referencing.
Thank you. Subsection C talks about planned development. The zoning board of appeals in the letter states that the exemption for planned development
I'm sorry, it states what?
states that the exemption sought for planned development, quote, is an intellectually dishonest claim, and once more ought to be viewed as nothing more than an attempt to circumvent the bylaw. Do you understand why, close quotes, do you understand why the zoning board of appeals said that? What's intellectually dishonest about the claim?
Well, I think it's really important, and I have to really stress that, again, we all live in these communities, and we have representative government. These are the people that make up these boards that live in these communities, and we come up with bylaws and we come up with committees to protect the town. And we've seen things that have happened in the past here in Somerset, and we take our laws like we all do very seriously. So when someone, in my opinion, when someone comes in and makes an inference that, well, this is why I don't need to look at that one, this is why it doesn't meet that standard, I think that people in these positions might be offended by that and say, no, that it's important to us. That's why we want you to come before this committee and not bypass the bylaw. And I think that in this case where there are few examples where a company has the ability to go before the EFSB and get approval to bypass these laws, people can become it's almost like an affront to them. I don't want to use something as strong as personal, but I recognize that there might be a curt reply, because it's like, why did we work so hard on these laws and committees if someone has the ability to step outside and go around them when others don't? And I mean, I hope that answers that's when I read this letter, that's the general impression I get, that the response they get from the company saying why they don't need to follow our laws and go before our committees, it can be one that's it's never going to be received well. And I think that's what I read from this letter.
Okay, thank you. Regarding subsection D, the parking and loading requirements, the zoning board of appeals in this section of the letter states that the company interprets the zoning bylaws as a vague, arbitrary code. Do you know why the zoning board of appeals makes that statement?
I believe it was because of the letter that SouthCoast provided about their bullet points on why they felt they didn't have to meet, or why they felt they received these certain exemptions. So there may have been something referenced in their letter that said, oh, this is a vague bylaw, and we feel that we don't need to meet this, or we seek an exemption. And then they look at that and say, there's nothing vague about it. Here it is in black and white. here's what it is. Here's what we want you to be able to do.
So the company sent a bullet point letter, is that what you said, to the ZBA?
When I look at this, sir, I'm assuming, I apologize, I don't know for a fact, but I'm assuming that the zoning board received or has that letter, the same one that they came to us on that April 20th meeting and said, this is why we're exempt from all your bylaws. They must have had eyes onto that and looked specifically at what South Coast was saying, why they're exempt.
Thank you. Just for a second, Mr. Runge, do you know if that letter, if it exists, is in the record?
I don't know, and I'm not aware of it, to be honest, unless, let me look around the room. Kathleen, do you know?
And I have an answer to that as well when Attorney Runge is finished.
Thank you.
Let me ask Kelsey Perry, Eric Runge speaking. I'm going to ask Kelsey Perry if she knows about the bullet point letter.
Yeah, it probably came from me. I'm not sure, Mark, if you're talking about just the zoning exemption petition as it is that I know I've sent via email that has that table in it that lists everything out. And I think I also may have sent you a Word document with some bullet points that are a little bit more layman's terms. But I'm not sure which document you're talking about.
But Ms. Perry, you're saying that you did send some letters, some communications, and email, et cetera, to Mr. Alucci, and in one of them you had a set of bullet points.
I believe so, yes. But it's really just in our zoning petition that was submitted to the EFSB. I'm not sure what page it's on. There's a table that outlines each specific point within the Somerset zoning bylaws and why we're seeking the exemption on that point by point.
Is this the table that's in the zoning board? I'm sorry, the zoning petition? You know, there is a table where you go through every exemption that's sought.
Yes.
That's what you sent to Mr. Alucci?
I would have to look back, but I believe that's what I sent. Yes.
All right, thank you.
Yeah, and Mr. Shea,
Yes, Mr. Ryan.
I believe it was, this is Attorney Pucci, I believe it was the zoning petition itself, which, as Ms. Perry pointed out, it has that table that's like bullet points that goes through them. And I should say, you know, a lot of that, the tone and the tenor of not with regard to the specifics about applicability of certain sections, but sort of the tenor was informed, I believe, by the zoning petition, which was sent. So the zoning board received that petition that was sent by Ms. Perry to Mr. Alucci, and then he sent it to them. So that is the, you know, sort of what they were responding to. I believe that they did have the opportunity, and members of the board did in fact read that zoning petition, because if you view the videotape of the meeting, it's very hard to hear a lot of it, but it was very clear that a number of the members had actually read the petition before they discussed it at that April meeting.
Thank you. Now, Mr. Alucci, on the last page of the letter, the May 1st letter from the Zoning Board of Appeals to you, there's a section that says use regulations pertaining to onshore export cables, and the ZBA asserts that quote, public utility uses are allowed in an industrial district. Close quotes. Do you know why the Zoning Board of Appeals draws that conclusion?
Sir, specifically why they draw the conclusion to what?
Where they say that public utility uses are allowed in an industrial district.
So I believe again that the zoning board's looking directly at the bylaw and you know, taking umbrage to the way South Coast is describing it as ambiguous.
All right, so you believe that the Zoning Board of Appeals did not think that the bylaw was ambiguous?
That is correct, sir.
And, oh, go ahead.
Shay,
Yes, sir.
Eric Runge for the company, and just a little concerned that we're having Mark Alucci kind of here speaking as if he's a member of the zoning board and opining as to what they think, and I'm just a little concerned about that as any kind of evidence in this proceeding.
Well, right, I can understand your concern. Our general rules in front of the EFSB are that we do provide for, we do allow hearsay evidence, and the rules of evidence tend to be looser than you would find in the Massachusetts rules of evidence that you would find in a court. But of course, the point you make, you're free to make that in your brief too, that Mr. Alucci's answers are not, we're not getting this from the horse's mouth. We're getting this secondhand.
Right, and I understand the looseness and allowing in hearsay. It's just more of a concern about him drawing conclusions about what the zoning board itself might do or say.
Well, your objection is noted.
Thank you.
And finally, the section 2 is entitled, section 2 of the letter is entitled, Mayflower Wind has misstated the town's zoning regulations. Can you throw any light on that? I mean, you've testified very well as to what you believe the zoning board of appeals believed and meant.
Yes, sir. Again, and it does seem to be the theme throughout the letter that I believe that it's a general term that in stating that misstating that the zoning regulations, in indicating that they're ambiguous, that they're flawed, that they're not narrow enough in scope, or they're left open to interpretation. That's not the case by the zoning board, and I believe that's what they're referring to there. But by SouthCoast Wind oversimplifying some of their statements as to how they perceive those zoning laws, that's where the ZBA is stepping in and saying, they're misstating our regulations, that they're clear. That's why you go before the zoning board if you had any questions as to their interpretation. But when you're just kind of speaking generally about them, you're misstating the zoning regulations when you're giving them those terms and adjectives that they disagree with.
Thank you. I don't have any more questions for you, Mr. Lucci. I have a few for Kathleen Souza. I'd like to ask Kathleen Souza a few questions, and then we can do I'll let everyone else have a chance to ask questions. Ms. Souza, in the testimony you submitted on behalf of the town of Somerset, you state that you're an alternate member of the Somerset Zoning Board of Appeals. What does it mean to be an alternate member?
So as an alternate member, I can give my opinion, I can give advice to the board. I sit in on the hearings, but I don't have a vote unless a board member was out and I was selected to sit as a voting member. But that's an alternate. I don't actually have a vote at the meetings.
Thank you. Have you ever communicated with a representative of SouthCoast Wind in your capacity as an alternate member of the Zoning Board of Appeals?
I have not.
Okay. I asked you to draw your letter to the letter. I draw your attention, excuse me. I asked you to draw your attention to the letter dated May 1, 2023 that we were just referring to, attached to the testimony of Tim Turner as Exhibit A. Do you have that letter before you?
I do.
Okay. Were you present at the April 20th, 2023 meeting of the Zoning Board of Appeals?
I was.
Okay. Who else from the Zoning Board of Appeals was present?
The entire board was present, I believe. Joe Finglas, Steve Catarat, Jim Pimentel, and Bernard Miranda.
Okay.
Also Arthur Frank, excuse me.
Thank you. Can you summarize what the zoning board?
Mr. Shea, it's important to know that the last individual mentioned by Ms. Souza is actually an attorney for that zoning board.
Yes.
The last one is not a zoning board member.
Okay, and what was his name? Arthur?
Attorney Arthur Frank.
Arthur Frank, thank you. Can you summarize what the people, what the zoning board of appeals members said at that meeting?
The discussion was pretty much, from what I recall, they were discussing drafting a letter that South Coast Wind had not reached out to the zoning board themselves. They hadn't reached out to discuss any kind of filing with the zoning board, and they were voting on writing a letter, just pretty much summarizing what you read.
And to the best of your knowledge, did the zoning board of appeals members, did they know that South Coast Wind had been dealing with Mr. Alucci?
I don't recall any discussion regarding that, and I don't know that, I can't answer whether they did or did not.
Let's go through the letter, then you might know better than I was asking these questions of Mr. Alucci. Now, as I mentioned before, section 2 of the letter states that Mayflower Wind has misstated the town's zoning regulations. Do you know why the zoning board of appeals has drawn that conclusion?
My best guess is just as they described in the letter, with regards to parking, the floodplain overlay district, those are pretty clear-cut bylaws. I don't think there's anything difficult about those bylaws. I think they're very well written and in place. I don't think, I mean, to assume that they wouldn't be handled by zoning, I don't understand why South Coast Wind would have that opinion of that.
You mentioned parking zone bylaws, and what was the other thing?
I think one of the other was a floodplains overlay district, minimum setbacks. I mean, something as simple, I think they had mentioned, putting in trees and plants, and that would be difficult. So to me, I mean, that's the simplest of the bylaws, and I'm not sure why they would need exemptions or to be able to skip that portion of zoning bylaws.
Thank you. Regarding the use regulations, do you understand the zoning board of appeals argument regarding substantially similar nature of the two uses?
Let me just bring that up. They claim that placing them in the category of being
I'm sorry,
substantially.
I'm sorry, can't understand you.
I was just, we're on to A, use regulations, is that correct? 2A.
Yes, please. Yes, please.
Yes, I understand that.
Okay, what is the argument about two uses being substantially similar?
My understanding is South Coast Wind was trying to say they're not similar, and that's why it should go to the siting board. But I could be incorrect in my interpretation of that.
Is it your understanding that a use that is similar to an allowed use is itself an allowed use?
Can you repeat that?
Sure. Is it your understanding, let me slightly rephrase this, is it your understanding that a use which is substantially similar to an allowed use is also an allowed use? That is, when a zoning bylaw allows certain uses, it also implicitly allows substantially similar uses.
Yes, that's my understanding.
And can you cite to anything that supports that proposition?
Not off the top of my head, I can't, but I do agree with it, but no, I can't give you an example that in recent zoning hearings that I've experienced.
Ms. Souza, are you an attorney?
I am not.
Okay. I think you said you thought the minimum setback requirements are not vague.
Correct.
And with respect to the planned development requirements, the letter says the petitioner contends that it cannot meet the requirements for tree planting, ingress, access restrictions, and street width. Why is it that these claims are characterized as intellectually dishonest, quote, intellectually dishonest, close quotes?
I mean, without them declaring why they can't, I mean, it's a pretty blanket statement to say they can't without declaring why or giving even one example of why not. I would think in my opinion, I would think there'd be an example of why not. They're pretty basic bylaws.
When you say they, you're referring to the company.
Correct, South Coast Wind.
Okay. Do you understand why in the section it talks about use pertaining to onshore export cables? Do you understand why the Zoning Board of Appeals asserted that, quote, public utility uses are allowed in an industrial district?
Without having seen anything from South Coast Wind to either the boards or the town administrator, my only guess is they were asserting that they weren't covered under our bylaws. That's a guess from me as to why they would put that.
Have you had any conversations with Zoning Board of Appeals members since that meeting? Have you had any conversations regarding the exemptions sought by the company?
I have not.
You have not?
No.
Okay. I don't have any more questions for Mr. Alucci or Mr. Souza. Does someone else from the siting board have questions? Mr. Wong?
I do not. I think Mr. Green looks
Mr.
like
Green?
No, I don't either.
Okay, Mr. Runge, do you have cross-examination for either of these witnesses?
I do have some questions for Mr. Ulucci. So am I pronouncing that correctly, sir? Ulucci, or is it Ulucci?
No, Ulucci, you have it.
Ulucci. All right, so Mr. Ulucci, you mentioned the importance of the laws, correct?
Yes, sir.
Are you aware that state law gives the company the right to seek the zoning exemptions they're seeking?
Yes, sir.
As town administrator, you're the chief administrative officer of the town of Somerset, correct?
Yes, sir.
All the other administrative officers of the town report to you?
I'm sorry, say that again, please.
I'm asking, do all the other administrative officers of the town report to you?
Oh, which administrative officers?
Well, you're the chief administrative officer, so I'm trying to understand, like, what is the scope of your authority? Are you basically in charge of all the other administrative officers of the town? Or is it?
Personnel employees, but not the boards.
Okay. So would your supervision include Mr. Turner?
Yes, sir.
And you said the boards would not report to you, such as the zoning board, the planning board, the conservation board, the board of health. Is that right?
That's true, sir. Yes.
I think you said you have had good interactions with representatives of South Coast Wind, or at least some of them. Is that right?
Yes, sir.
It sounded like in what you were responding to today that where you had some issues was potentially with regard to the host community agreement. Is that really the area you would identify as maybe somewhat more problematic in your interactions with the company?
Yes, sir.
When company representatives told you that they needed to go before the board, their board, before they could really engage in host community agreement discussions, did you understand that they, why they needed to do that?
Yes.
And have they told you that they have now gone before their board and they have been authorized to commence those discussions with you?
Yes.
Have you signed an NDA with the company about the host, a non-disclosure agreement about the host community agreement?
Yes.
All right, so you are in discussions, or you will be beginning substantive discussions about the host community agreement sometime soon, it seems. Is that right?
Yes, it does seem that way.
I think we had some questions about communications with the Zoning Board of Appeals about the project that you've had. Did you tell the zoning board members and alternates that you had instructed South Coast Wind to channel all town communications through you?
No,
When was the last time you communicated with the Zoning Board of Appeals about the project?
it was when I had sent the email indicating why South Coast wanted to seek exemptions through the ESFB, and then the reply back from the chair.
Okay, and I think I listened to part of the YouTube recording of that zoning board meeting, which we have included in the record in response, supplemental response to EFSB-17. I think I heard in that you communicated with the board around April 10th. Does that sound right?
It does sound right, because I know it would have been that first week of April, so it was probably around the 7th.
Okay. I don't think I've seen that communication. Do you know if it's in the record or has been provided to your counsel?
I believe it's been provided to council. I don't know if it's in the record, sir.
Okay. I would like to make a record request for all written communications between Mr. Yulucci and the Zoning Board of Appeals about the project. And that would include the April 10 communication and any others.
As they pertain to South Coast, correct?
Correct, about the project, the South Coast Wind project.
And that's all written communications between Mr. Lucci and the Zoning Board of Appeals.
About the project, yes, and that would specifically include the April 10 communication, or the one that was sent around that time.
No problem.
Thank you.
All right, that'll be record request RR-EFSB. And I'm going to ask Mr. Brock, is that 37? We'll go off the record first. Okay.
You just, sorry.
Pardon me?
Sorry, I was just speaking to my colleague. I tried to get muted before I did that. I was just noting to my colleague about, let's get that one out right away on the list of the ones that we're getting out.
Yes, yes, it's 37.
Okay, so we'll go back on the record. That record request is RR-EFSB-37. Mr. Runge, please continue.
Thank you. And just to be clear, that one does include any email correspondence.
Emails, yes.
So, Mr. Yulucci, have you read any of the filings made by the company in this proceeding?
The filings that South Coast has put before the ESFB.
Any of the filings, yes, that have been made in this proceeding, yes.
Just the ones that were presented at the meeting that we had with South Coast that they were going to submit.
So there have been a whole bunch of responses made by the company to information requests, record requests, some from the town of Somerset itself. Have you seen any of those or read any of those?
I have not read all of them.
Have you read any of them?
Just the ones that were initially showed to me.
Do you recall which ones those were?
The specific exemptions that South Coast was looking to have presented before the board.
Okay, well, that sounds like the petition for zoning exemptions that you're talking about. I'm asking, more recently, there have been a number of responses from the company about zoning issues and impacts to the town, and along those lines. And I'm just curious whether you have actually read any of the responses that we have made of that sort.
No,
I
I don't.
object. I object.
What's your ground for objection, Mr.
So
Boucher?
this is now getting into attorney-client privilege beyond my waiver on the specific issue of the zoning board letter. So the only place where Mr. Ulucci would possibly be getting the voluminous recent filings from SouthCoast Wind would be through counsel, because he's not on the service list. And so we're getting into things which I may or may not have provided to him as privileged information, and it's none of the company's business, and it's totally irrelevant. And I'll add a further point is I wouldn't have many clients left if I sent my client every single piece of paper that I get in a proceeding like this. There are thousands of pages of documents. So to try to imply that, you know, first of all, he wasn't required to do any homework in relation to this. He was just required to reconstruct a timeline on communications relevant to the zoning board letter, and to try to go down a line of questioning about what he may or may not have reviewed in connection with the proceedings generally is completely irrelevant, and it also goes into attorney-client privilege information.
Mr. Pritchett, let me ask you, you know, in depositions, a very standard early question in depositions is to ask the witness, what have you reviewed in preparation for this deposition? And every deposition I've been at, the witness responds. I mean, has that been your experience also?
Well, he can ask that. I wouldn't have objected to that question. What have you reviewed in preparation for today's testimony?
Well, but Mr. Runge is asking whether the a certain specific subset has been reviewed. I don't see how that question is really different from the question that's asked at the beginning of pretty much every deposition that I've attended.
Can I respond?
Yeah, Mr. Runge, please go ahead. Excuse me.
I'd be happy to respond, and this is all quite relevant. Mr. Ulucci is the Chief Administrative Officer for the town, and the fact that he hasn't read any of the company's specific responses to concerns from the town concerns me. And he should, you know, if he hasn't read them, he should say it's a factual question. He can say yes or no, and that's all I'm asking for. If he says no, then that tells me that the Chief Administrative Officer for the town is not even reviewing these responses that the company has spent significant time on providing for the benefit of the town.
Yeah.
So
I
have a reply to that. But I mean, that's an outrageous comment. If we're going to start making speeches about what the company is providing, you know, don't mistake quality for quantity. Okay, so we're in a proceeding and we're opposing exemptions to zoning. What I provide my client is none of the company's business. But if we want to pontificate about it, my comment would be all of these thousands of pages are largely irrelevant, and my client would not be interested in any of them, and nor do they go to any of the issues that we're litigating in the case. So again, what I'm providing to my client or not is none of the company's business, is privileged information, and it's irrelevant. If he wants to ask if he looked at a particular document, he can ask him that.
All right, I think Mr. Runge's question is sufficiently narrow. And Mr. Lucci, you understand Mr. Runge is not asking about any communications you had with Mr. Pucci. He's just asking, and I'll ask you, and I'm going to allow the question, overrule the objection. And Mr. Runge, because we've had so much of a colloquy on this, I'm going to ask you to re-ask the question.
Sure. My question is, the company has provided numerous specific responses to the town's concerns in responses to information requests and record requests. And my question is, have you read any of those?
Without knowing specifically what you're referring to, I don't know, but I mean, I can say that in general, I don't. And I recognize that, you know, you might be trying to build up a case to discredit me, or which I understand, but for the board, I just want the board to recognize that, that's why we have these different committees. We have the attorney and we have these people in these positions that are reviewing them because thousands of pages for me to go through all of them, I haven't, and I wouldn't be able to do anything else, as you indicated, sir, with as the chief administrative officer for the town. There are a lot of things that come through this office, and my bandwidth is only so large, but I'm confident in the people that get back to me with the information I require to best inform the board of selectmen. But to your original point, no, I certainly have not read everything.
Okay. So who among town officials is actually paying attention to the substance of the evidence presented in this case?
What are you referring to?
Well, I mean, the town asked several information requests to the company. Are you aware of that?
Which informational requests?
Town of Somerset information requests 1 through 13.
Yes. And is this the one submitted by Mr. Turner through Attorney Pucci?
No, that was testimony. I'm asking about information requests that the town asked of the company in this proceeding.
Okay, what are you asking?
Are you aware? I'm asking, first of all, are you aware that the town has made those information requests to the company?
Yes.
And did you review the responses to those information requests?
Again, without seeing the specific requests that you're referring to, I'm not 100% sure.
So my next question is, who among town officials is actually paying attention to the substance of the evidence presented in this case, such as the responses to those information requests?
So all of our information is going through our attorneys. So when we get a reply from a specific board member or health agent or a citizen's petition, it's all going through our attorney.
Right. I understand it goes through the attorney, but there's an actual client connected to the attorney. So I'm trying to understand who among the town officials is the one that's actually paying attention to the substance of the evidence presented in this case.
Well, I would say that everyone plays a part in reviewing that.
Okay. And what part do you play?
The meeting deadlines, meeting dates, making sure that the information gets these things on time, that it gets to the attorney, that we meet these deadlines, that the responses are complete, that they, that this information gets before the board.
So that sounds more like process. Is there somebody who's paying attention to substance?
Yes, the attorneys are certainly paying attention to the substance.
So are you aware that the EFSB made some record requests to the town on July 27?
I know it was mentioned to me by our attorney. I don't know specifically what those requests were. I don't recall them off the top of my head.
All right. Well, one of them was to specify what conditions the town would want imposed on the project in the event that the EFSB grants the company's zoning petition. Did you know that?
Not the particulars.
I object.
What's your ground?
It's all attorney-client. There would be no way of Mr. Ulucci having those except through me. It's attorney-client is totally irrelevant. And he was produced today about the zoning board letter. Mr. Runge can ask him what he's reviewed in preparation for his testimony today. Everything else goes to attorney-client privilege.
So you're saying that if the record requests that were asked on July 27th, that anything about that is attorney-client privileged?
Yes, how would he know about it other than through his attorney?
All right, Mr. Runge, do you have a response?
Well, I suppose he might know by paying attention to the proceeding rather than relying on his attorney. But aside from that, I'm really just asking whether anybody has contacted him about the record request and responding to it. I'm not asking about the substance of it.
Okay, so you understand the question.
It would come from the attorney.
Okay. I understand your objection, sir. So you understand, Mr. Lucci, that in your response, you shouldn't say anything about a conversation you've had with Mr. Pucci or email exchange, but just answer the questions to the best of your ability while excluding any attorney-client communications.
Okay, thank you, sir.
Okay, Mr. Runge, could you re-ask that question about the record requests?
The question was simply, were you made aware of that record request that you provide the conditions that town would want imposed if the zoning board, the citing board were to grant the zoning exemption petition?
Not that
I repeat my objection.
Your objection is noted. The objection is overruled. Go ahead, answer, Mr. Pucci. Mr. Pucci, I beg your pardon. Excuse me, sir.
not that I recall.
So I want to turn to the letter that Mr. Carteret sent you, the May 1, 2023 letter that you were asked about earlier today. And I want to ask you, when you received that letter, did you read it?
Yes, sir.
That letter seems to make some strong assertions about South Coast Wind and the project, correct?
What kind of assertion, sir?
Well, I think the ones that Mr. Shea read earlier today, such as misstating or mischaracterizing the zoning exemptions, etc., being intellectually dishonest, those kind of assertions.
Yes, whatever's in that letter, yes.
Did you follow up with Mr. Carteret to investigate his assertions?
No, sir.
Did you follow up with South Coast Wind to investigate Mr. Carteret's assertions?
No, sir.
Did you provide the letter to South Coast Wind?
Yes, I believe through our attorney.
Was that in response to an information request around June 5th?
No, I don't believe so. I'm not sure. It could have
Well,
been. I don't know. I'm sorry.
I'm pretty sure that the company did not get it until June 5th. So did
wasn't
you
aware when you received it?
did you think that maybe it would have been a good idea to inform the company about this letter back when you got it on May 1?
No, they made their position quite clear.
Did you discuss the letter with anyone other than counsel?
I may have discussed it with the Board of Selectmen.
Are you aware that the town made a record request in this proceeding to obtain the company's option to ground lease at Brayton Point?
I'm sorry, what is it?
It's called an option to ground lease. Just question is really, are you aware that there was a record request for that document?
No.
I think you said you're involved in discussions with the company about a potential host community agreement, correct?
Yes, sir.
Who else on behalf of the town is involved in those discussions?
The Board of Selectmen.
Any other administrative officers like Mr. Turner or other people?
No, not that I can recall.
Do you support the South Coast Wind project coming to the town of Somerset and building the project?
I do within the parameters of our bylaws and our committees, yes.
And you are aware that the only exemption that South Coast Wind is looking for is the zoning requirements. Are you aware of that?
Yes, sir.
Not your other bylaws, correct?
Yes, sir.
Right. Thank you, Mr. Iulici. No further questions.
I would just qualify one thing, though. I believe the the noise is outside the zoning.
Right, the noise bylaw, and I do believe we've had testimony in this proceeding that says the company is intending to comply with the noise bylaw.
Thank you, sir.
You're welcome. I'm all set. Thank you, Mr. Shea.
Why don't we, I'll let you do, why don't we, it's 11:39, why don't we break for a few minutes now? And I'd like to talk during the break on a Teams meeting with the siting board team, Mr. Green, Mr. Wong, Ms. Devaka, just about I guess we have got a pending request for an extension to August 25th for responding to 2 of the record requests. That's right, Mr. Pucci?
Correct, sir.
Okay, well, I don't want to make a ruling on that without consulting with my team. So instead of waiting for 15 minutes, why don't we break for 20 minutes? I'll see you back here at noon. Thank you very much. Off the record.
Mr. Shea, do you still require me to be here?
I'm sorry, who said that?
Oh, Mark Iucci, I'm sorry, sir.
Oh, that would depend. Mr. Pucci, do you have recross?
No, I have no questions for either Mr. Iucci or Ms. Sousa.
Okay, then I don't see any, unless, is there someone from the siting board who has questions for Mr. Iucci?
I do not.
Okay, not hearing any, then Mr. Iucci, I think you're excused for the day. Thank you very much for showing up. I appreciate your help.
No,
Mr.
thank
Shea.
you. Thank you to
Sorry.
the entire board.
Mr. Shea, am I excused as well?
Yes, you are
Thank
excused, Mr. Sousa. Thank you very much, and thank you for showing up today.
You're welcome. Bye-bye.
Okay, let's take a 20-minute break. I'll see you back here at noon. Thank you. Hey, Wayne, I got onto the, and it says, you cannot start your video because the host has stopped it. Oh, thank you. Thanks, Wayne. I'm on now. Thank you. We're off the record. We're off the record. Mr. Runge, I see a lot of, oh, I'm starting to see more people. Ms. Flood, Ms. Perry.
Yeah, I think we have our witnesses all present here, it looks like.
Okay, that's great. That's great.
We'll need a direct examination of Ms. Earhart when you have a chance, whenever you're ready.
Why don't we let's go back on the record. Mr. Runge, do you have any direct examination?
Ms. Sepia will conduct it for Ms. Earhart.
Yes, good morning, Ms. Earhart. Could you-
Just 1 second, please. Okay, thank you.
Could you please state your name, business affiliation, and address for the record, please, Ms. Earhart?
Yes, Jennifer Earhart. I'm a project manager for air permitting and compliance services with AECOM. My office address is 625 West Ridge Pike, Suite E100, Conshohocken, Pennsylvania, 19428.
Thank you. And on whose behalf are you testifying in this proceeding?
SouthCoast Wind Energy.
Are you the same Jennifer Earhart who sponsored a record request in response in this proceeding?
Yes.
And what is your role with SouthCoast Wind?
I'm a contractor who has assisted with the development of air emissions estimates for the construction operations plan and the Outer Continental Shelf air permit application. And I also supported section 2.2 and attachment C of the FEIR.
Okay, and I think it's fairly clear from that, but could you please just state which topics you're prepared to testify on today?
Yes, in general, I'm prepared to testify regarding air emissions estimates and specifically those items I previously mentioned.
Was your resume submitted as an attachment to the participant list filed by SouthCoast Wind in this proceeding on Friday?
Yes.
Have there been any changes since its submission?
No.
And was the response to the record request that was submitted during the course of this proceeding that bears your name prepared by you or under your supervision?
Yes.
Do you have any changes to offer for the record at this time to any of the materials that were submitted under your name?
No.
Do you adopt all of those materials as your testimony in this proceeding?
Yes.
Okay, Mr. Presiding Officer, I think the witness is ready for further questions. Thank you.
Thank you, Ms. Zepiel. Mr. Pucci, do you have any questions for the witnesses?
Sorry, I thought I was muted. No, I do not.
Okay, this is about the, today was the day we were going to talk about the FEIR. You don't have any questions on the FEIR?
Correct. I'm going to direct my comments on the FEIR to through the MEPA process and not ask questions in these proceedings related to that.
Okay, then let me ask Mr. Green, do you have questions of the witnesses?
I will defer to my colleagues.
Mr. Wong?
Thank you, Mr. Shea. Ms. Divakar will start and then I will follow up.
Thank you. Ms. Devakar?
Thank you, Mr. Chair. Please give me a minute.
We have a bit of an echo there. Oh, Ms. Devakar, you're muted.
No.
No, your mute is off, but we do have an
May I suggest we go off the record?
Let's go off the record, excuse me. Yes, but right now. Yeah, let's work on this. Smith and Wayne, you're both in the same room, is that correct?
Yeah. Can you hear me better now?
I can hear you. Yeah, we did have a real echo there for a while.
Yeah, a couple of microphones were on. I'm sorry about that.
Oh, I see. So you have your microphone off, but Wayne's microphone is on.
Yeah.
All right, that's very helpful. All right, we can go back on the record then. Thank you. Back on the record, Ms. Devakar, please proceed with your questions.
Thank you, Mr. Shea. I'd start with some questions on air emissions, and then I'll follow up on other sections, which will include some on stormwater,
I'm sorry, then I'll follow up on other sections. What?
including stormwater, wetlands, and water.
Pardon me, before you get to your questions, I apologize, I overlooked something. I said I would come back with a ruling on Mr. Pucci's request to postpone the response to EFSB RR-EFSB-29 and RR-EFSB-30. And Mr. Pucci, you want to have until August 25th to respond to those record requests? You're muted, sir.
Yes, on 29 and 30.
Yes, on 29 and 30. Okay, well, we discussed the matter during the break, and that motion, your motion will be allowed. So the response to EFSB RR-EFSB-29 and RR-EFSB-30 will be due on August 25th.
Thank you.
Thank you, Mr. Pucci. Now, I apologize, Mr. Vaca, I interrupted you, but please resume.
Thank you, Mr. Shea. So let me instead begin with the installation methods, the cable burial methods, if that's okay. So in the discussions on determining installation methods as well as cable burial depths, 2 studies were referenced during our hearings earlier. One was the cable burial assessment study, and if I recall correctly, the benthic habitat monitoring study. I'd like you to identify the attachment number that includes details of these studies. Are these attachments E and J submitted on the 24th of July?
Yes, are these the ones subject to the confidentiality motion? Mr.
Yes, I
Run?
believe Mr. Runge speaking, and yes, I believe they are the 2 that you identified earlier today, and Mr. Ryer can speak generally about them, but not as to the contents.
I just want a yes or no answer. That's fine. So now replying to the question on protocols to be followed if any run of the ECC would be deemed infeasible for cable laying, the company mentioned that this requirement will be provided in section 4 of the FEIR. Just want you to point me to the content in the FEIR, and that may require sharing your screen. Just want to know where this has been addressed in the FEIR.
Thank you, Eric Runge speaking. We have your question. We're looking for that.
Yeah.
Mr. Ryer, I notice you're on mute, so.
Yeah, Mr. Rye, you're still on mute.
Mr. Ryer, you're not muted. I can't hear you.
Yeah, Mr. Rye, why don't you speak and we'll see if we can hear you. Unfortunately, we cannot hear you. Now it seems that you're muted. Occasionally now the mute icon is on. And now the mute icon is off.
Maybe we want to go off the record again.
Okay, yes. Let's go off the record now.
You should, Mr. Ryer, if you could check the microphone button and see what the microphone is selected as.
4.1 is this 5th paragraph. I think that we might have somebody here in the room, not Tim Ryer, but somebody else, Jamie Durand, who can answer the question. This is Eric Runge speaking.
Please go ahead. Yeah.
Yeah, let me just ask Mr. Ryer, well, I can ask, but you can't answer, Mr. Ryer, how things are going on your end. You're still trying, but it doesn't seem to be working. Yeah, I can
Or-
see I can see
Or
that
I
you are.
could, or Mr. Shea, or I could move on to. Okay, I'll let,
You want to go back on the record, Mr. Vaca?
yes,
Okay, let's go back on the record.
Hi, this is Jamie Duran from Power Engineers. So section 4.1, which is entitled Offshore Export Cable Installation and Landfall, provides a discussion on the installation of the cable. And I believe it's probably on page 4-3. It's I think the fifth full paragraph in section 4.1 talks about alternative burial methods and techniques that the company would consider. And that goes on, the discussion goes on to pages 4-4.
so is that the company's response to protocols? That the company may have?
I think what it is a response to is the different burial tools that the company has at it, will have at its disposal, depending on the seabed characteristics and if there are other obstacles on the seafloor. I know part of the discussion within section 4.1, is regarding, I think this was asked at one of the previous hearings, was the use of secondary cable protection. So that's discussed in 4.1, in the event that the cable cannot be buried, that we would use secondary cable protection.
Thank you, Mr. Duran. My question was specifically regarding protocols. So maybe, what I'm going to, if it's okay, I'm going to switch to air emissions for now, and maybe Mr. Rare can also,
Yes.
hopefully he will be able to join us then. So if that is okay, I will switch to air emissions at this point. Mr. Shea, is that okay?
That's fine.
Okay. Now, please refer to attachment C of the FEIR. Tables 1 to 4. Now, these are on pages 2 and 3. Now, please explain how these tables feed into each other. I understand that the tables for Fall River is a subset of the other tables. Am I wrong about it?
That is correct. The on-road emissions from table 2 are a subset of the construction emissions that are in table 4, and table 3, the vessel emissions, feed directly into the vessel line within table 4. Does that answer your question?
Yes, thank you. Now, based on these tables, can you explain how these figures would compare to your earlier estimates, which were observed in the DEIR certificate as higher compared to other similar projects?
Right. In record request EFSB 19, which we provided on Friday, there's a comparison provided that explains the FEIR emissions are simply the on-road emissions that could take place within Fall River, while the DEIR estimates were a very conservative estimate, which included more aspects of the air emissions, including non-road emissions, which are like
I'm sorry, including what?
Non-road.
Fine.
Non-road emissions. So that's like cranes and forklifts, along with actual physical construction emissions for earth moving. So all of those were lumped in and conservatively estimated in the DEIR. So the FEIR numbers are much lower, as you can see.
So how do these estimates compare to emissions on similar projects? Can the company comment on this?
We believe when we revised them, we brought them more in line with similar projects, but I don't have a comparison for that to provide you.
Okay. Are there any projects that you might name that you compared these emissions with?
I don't have any available for
Okay.
you right now.
Okay. Now, what are the standards against which these figures need to be interpreted? If I were to interpret on my own, what are the standards against which I would interpret these figures?
So construction emissions are generally not compared against the standards that we generally think of in air permitting. For stationary sources, which are permanent sources, there's thresholds for where a major source is considered, and that in general is 100 tons of each pollutant other than CO2 that is listed on those tables, depending on whether they're in attainment or not of certain standards. That threshold can change depending on the area. But construction emissions, as I said, are not generally compared against those thresholds. That's just a frame of reference.
So please help me understand this better, especially because we understand that air emission trouble or impacts to air quality are going to be highest during the construction phase.
Mm-hmm.
So when you say that your estimates are better now, they are less conservative. So in terms of construction emissions during the construction phase, how do we know that they are better?
So we reduce them based on updated construction schedules. The original emissions were based on very preliminary schedules that did not have as much detail, and now there's more detail that was able to be used to revise those emissions down. And we've compared against all of the regulatory requirements. But as I said, construction emissions, since they are temporary, they don't have the same requirements for permitting as stationary sources that are permanent.
So what are these regulatory requirements that you're referring to?
Regarding construction or stationary, sorry?
Construction.
So as I said, temporary sources don't have these, so we confirmed that there were not any regulations that required additional analysis. I don't have the specific citations because they're generally not required.
Is there anyone else who wants to add to this? Moving on, now we had a discussion of the NAAQS and compliance requirements on that during one of the days of the hearing. Now at 2, 3, and 6, I'm sorry, Alan, it's 2-3 and 6-2 of the FEIR. The company mentions that due to temporary nature of construction emissions, no long-term impacts on NAAQS can be expected. I'd like to try and understand the statement better. So just to clarify, now I know we've had this discussion before, just for the record, I understand that the NAAQS is always expressed on a yearly basis. Am I wrong?
There are various NAQS, and if I refer to that as NACs, is that all right? Because
sure,
that's my natural tendency. Just wanted to make sure.
I just had
various...
Alan in mind. Yeah, sure. Please go ahead. Yep.
Okay, so there's various averaging times for those standards. There's a concentration and an averaging time given, and then there's an analysis of, it's called the form of how you determine whether it's in compliance. Most of those are on an annual basis. There are some, I'm going to give lead as an example. We're nowhere near any concern about lead, but it has a rolling 3-month averaging period that's not to be exceeded. So not every single NACS is on an annual basis, but most of them are either that or averaged over 3 years or 3 months. There's a variety.
So for the quality parameters that we are concerned with on this project, are they usually averaged over the 3-year period or annually?
I'm sorry, are they usually averaged or what?
Over a 3-year period or annually?
So if we're looking at, do you have any specific pollutants that you're concerned about?
No, I understand that there are a few that you have said are particularly important when it comes to these projects.
Okay.
So just, yeah.
For example, nitrogen dioxide, the primary standard is a 1-hour daily maximum concentration averaged over 3 years.
Okay.
Well, there's a second one, primary and secondary standard, which is an annual mean. So that's 1 year.
Okay.
And then ozone is the 4th highest daily maximum concentration averaged over 3 years.
Thank you.
Yep.
So then my question would be, so is it correct to assume that air quality impacts that are temporary, in this case during the construction phase, cannot be accurately compared to the NAAQS recommended levels, since NAAQS is time aggregated?
Yes, there's a challenge in trying to compare those. It's not an apples to oranges comparison.
Correct. Thank you. Now, does the company think that there is a likelihood of objectionable short-term impacts in or around the site during construction?
I don't know if I should be the one answering to that one, but
this is Kathleen Freeman. As we've stated in our filings and our response to record request EFSB 8, in accordance with Massachusetts regulations 301 CMR 11.02, the project does not meet or exceed any review thresholds related to air quality, including particulates, PM 2.5 and PM 10, because the project does not involve the construction of new or expanded stationary sources. And with respect to construction impacts, the estimates that you see in our response to record request EFSB 19 are unmitigated. That's pre-mitigation, particularly with respect to dust. And we anticipate any estimated dust emissions through mitigation will be substantially reduced. So based on our analysis, we do not believe that there would be any adverse impacts during construction, because again, we plan to undertake mitigation measures.
Yes, my question is more in the context that we heard that there are no standards against which these temporary impacts can be for now compared to, right? Even then, does the company feel that there is no likelihood of objectionable short-term impacts during the construction phase?
Kathleen Freeman, we're going to do our best that there won't be. I would call up the town of Somerset had mentioned a land court decision about dust. And in that decision, the judge had even noted that monitoring, is not meaningful, and that it's and the expert, he acknowledged the town expert basically saying that it's virtually impossible to satisfy a zero dust standard. And the best you can do is implement mitigation measures. I know as a former EPA official that EPA has published documents about best management practices and how they work in terms of mitigating dust, which I know is a concern by the town of Somerset. And there is an EPA publication that is cited in recent years by various state agencies that states that best management practices like applying water or silt fences can mitigate as up to 80%, sometimes more, of dust emissions during construction.
Moving on at 2-3 of the FEIR. The company states that it conducted supplemental, refined, and more detailed analysis of projected air emissions from vehicular traffic emissions. The first help I need is, can you point me to the record, any exhibit or attachment to the FEIR which describes the this kind of a detailed analysis or a new refinement in methodology followed?
I believe the detail is provided in attachment C. If you're looking for beyond that, I am not aware of any additional details provided, but attachment C
And Kathleen,
discusses.
yeah. And Kathleen Freeman, part of the adjustment reflects the actual construction times expected and the acreage. And that is mentioned in, I believe is it section 4 on construction, that onshore construction is estimated to be 2 to 3 years rather than the 1 year period reflected in the DEIR conservative estimates. And the horizontal directional drilling operation is 2 to 4 months. The pre-lay grapnel run is less than 1 week. The cable lay and burial is 1 to 2 weeks. And the cable pull-in less than 1 week, and using those adjusted, more accurate construction times. Jennifer at AECOM reran the numbers, and our record request response to EFSB-19 provides a table as requested by the siting board, comparing the DEIR numbers and with the adjustments, and then in addition, also the FEIR environmental justice area emissions, which are mainly, and Jennifer, you can correct me if I misspeak, mainly vehicular emissions, since Fall River is located across the Taunton River. We don't expect the dust to make it over the Taunton River into the Fall River EJ communities. And maybe Jennifer, you could speak more to the difference in the table. If we can call up that table, it would be helpful.
No, we can skip that. You know why? Because what I'm trying to understand is, you do mention that there has been a detailed analysis by which these numbers have been refined. My only question is, all that you have mentioned, I have seen it in the FEIR. So am I to understand that a recalculation of the acreage and a refinement of the construction schedule is what has informed your estimates now?
Yes, those are the main factors that updated the numbers.
Okay, that's all I wanted to know. Now, coming to the point that Ms. Freeman was making, that construction periods, the construction period has been mentioned to be 2 to 3 years. Do we have a better breakup of when we are expecting these air emission impacts to be maximum? 2 to 3 years is a big block of time. Now, in terms of impacts and monitoring, do we have any more focus at this point in terms of what the period is going to be?
Kelly, can you take
for the company? Is my audio okay?
Yes.
Okay. Yes. So I believe that for the original modeling effort, and Jennifer, please clarify if I have any of this slightly incorrect, but I believe for the original modeling effort, we looked at the entire potential construction window onshore, that entire 2 to 3 year period. And in the updated analysis, it takes into account the likely or indicative construction phasing. So we did this in line with the phasing that's described in the traffic assessment that was developed and submitted as part of our DEIR. And we would expect that the greatest dust related and other sorts of related emissions would be during the civil work phase when earthwork is underway. And I believe we do have some assumptions about the potential durations of those phases listed in that traffic analysis report. And I might be able to find them and cite them if that would be helpful.
Yeah, that would be very helpful. We could either put in a record request or you could take your time. Maybe we
I think I have it.
Okay, that's better. Yeah.
Okay, I think I have it. So we assume that construction activities for the converter station would take, and that's the 10 acreage, the 10 acres of area on site, that there would be, the construction would take about a year, and it would be composed of 3 phases, about 1 month of mobilization and site preparation, about 5 months of earthwork, foundations, and below grade conduit and vault installation. And that would likely include the horizontal directional drilling activities as well. And then phase 3 would be about 6 months of steel work, bus fittings, and other above grade work.
I'm sorry, field work, what?
Then,
Phase 3 would be
sorry,
about
steel.
6 months of field work, and then what did you say?
Instead
Bus
of steel work,
fittings?
it was actually steel
Okay.
work, bus fittings, above grade conduit, and grounding work.
Thank you.
So
That's
it would really be that first year that would be most of the material moving around. And then the following year would be primarily installation activities. So putting electrical equipment on foundations and within buildings.
That gives me a lot of clarity. Thank you. Yeah. Now at page 4 of attachment C of the FEIR, the company lists onshore sources that would affect air quality during onshore construction as fugitive dust, vehicular emissions.
I'm sorry, fugitive dust, vehicular emissions.
And carbon dioxide emissions from generators. Please let me know if I missed out any other source that you particularly mentioned.
So to be clear, the carbon dioxide emissions from generators is not specifically in the EJ area. I'm looking at what I believe was the final attachment C, and I'm missing page 4, to be honest. So I want to clarify. It was page 4, you said, correct?
Yes, unfortunately, yes.
Okay.
Kathleen Freeman, it's actually page 3, but it's page 4 if you include the blank.
Yeah, because it's not.
Okay. Thank you for that clarification.
Yeah.
It's the one with the 2 tables, Jennifer.
Yes, sorry, I just needed to get to the right place. So you mentioned carbon dioxide from generators, correct? In your list of items. So that is actually going to be in the construction area itself, not in the EJ area.
Yeah, well, I'm concerned with more than the EJ area. So I'm just understand if these are the sources, or did I miss out on any?
So in total, sources can include the vehicular traffic. There's also non-road construction equipment, which I mentioned earlier, includes things like the forklifts and cranes and other engines. There are generators that they produce more than carbon dioxide. The carbon dioxide was called out because those were the largest source of it within the table. So that's why that was specifically called out. And then, as you said, fugitive emissions.
So just so I get the whole picture, there is a mention of MOVES as the methodology followed to estimate vehicular emissions.
Yes.
Now, similarly, for the other sources, can you point us to what are the methodologies that were followed? And yeah. And who recommends these methodologies, or what is the basis of following them?
So the one you mentioned is EPA's MOVES program. It's an EPA model that you can get emission factors for different types of vehicles at different points in time.
Okay.
So they project future emissions based on requirements in the regulations for what cars are required to do, or trucks. The construction emissions, sorry, I'm going through my spreadsheet. Let me pause for one moment, gather myself, and get you an answer.
Please take your time, no hurry. Yeah.
So the generators themselves are based on emission factors from a source called AP42, along with new source performance standards. So depending on the age of the generator, new generators are required to meet certain emission standards. So those are used. And then the other source I mentioned, AP42, is an EPA document that is used to estimate emissions from different sources. The fugitive dust emission factor also comes from the AP42 document. And then for the non-road equipment, those also come from the EPA's MOVES program. I believe that's all the sources I listed.
So I'm wondering if we have the AP42 document that you were mentioned, that you've been referring to, the EPA document.
It's available online.
Online? So
yes.
Yeah. Now, since this is a publicly available document, can I place a record request for this?
Yeah, yes, you may. We've done that before because it's hard to get something into the record just because it's a public record, it's a public document. So that would be record request RR-EFSB dash, I'll go off the record now. Alan, what's the number?
$38.
Okay, let's go back on the record. RR-EFSB dash 38. And could you state again, Ms. DeVaca, what exactly you're looking for?
So this EPA standard AP42 that Ms. Eckhart was referring to.
Okay.
If we could have a copy of it submitted.
Thank you. Do you understand what's being asked for, Ms.?
Yes.
Tell me how the right way.
Earhart.
I'm sorry,
Earhart. Yeah.
Earhart. Oh, okay. Thank you.
I'm sorry for mispronouncing.
Not a problem. I'm used to it.
Okay, moving on. Now, I'm trying to find the same for different other sources that have been mentioned for, especially during the construction phase. Now, according to the company, offshore sources that could affect onshore air quality are construction and operation of the transmission connector facilities at Brayton Point. Before I move on, let me give you the reference. These are pages 3 to 4. There is no number to this. It is there is no page number there. It is the third and the fourth page of the attachment to the FEIR. So in there, the company mentioned that offshore sources that could affect onshore air quality are construction and operation of the transmission connector facilities at Breton Point, vessel emissions while in transit to and from the port during construction and operation of offshore infrastructure, and
I'm sorry, during the construction and operation of what?
offshore infrastructure,
Thank you.
and vessel emissions during the laying of offshore export cables near coastal areas.
Okay, so is your question what the factors are used for those?
Yeah, the methodology. It's the same question, just to understand how we get to these estimates.
Wanted to make sure. So for the vessels, the factors used are they used EPA's Port Emissions Inventory Guidance document with the subtitle Methodologies for Estimating Port-Related and Good Movement Mobile Source Emissions from 2022. All of the other sources you listed, I believe I already covered. So they were covered with AP 42 or moves or regulatory factors.
Okay, great. Thank you. Now, next question would be, now, in terms, I think I kind of know the answer, but I'm still going to ask you, in terms of measuring temporary air quality impacts in order to capture worst case scenarios during construction, are there any standard methodologies followed?
Generally, there are some mitigation done, but there's not usually measurements occurring during construction.
Okay, thank you. I'll now move on to some questions on wetlands and water.
Ms. DeBaca, I understand that Mr. Ryer now has audio. If you want to jump back to cable installation.
Yeah, and may I test my audio? Are you able to hear me? Great, thank you. Apologies for the interruption there.
Let me get back to those questions. I think those should get done before our lunch break. Sorry. Just give me a minute. So, while you were away, Mr. Ryer, Mr. Duran was trying to answer if there were any protocols that the company has come up with that the company would follow if any run of the ECC was deemed infeasible for cable laying. I was curious if you had anything to add to what Mr. Duran said.
And I apologize if I missed what Mr. Duran said earlier. I would add generally the protocol is as summarized in the FEIR in general at 4-2 and 4-3, and I'll quote certain sections here and summarize as well, or paraphrase if you will. Generally, the first attempt will be to bury the cables with the main tool. So say, use the proposed, be it a type of jetting sled, jetting plow, if you will. And during the process of laying and also after laying, the achieved burial depth will be monitored. If the achieved burial depth has not been has not been achieved, or the target burial depth that's set as required, one of two alternate sort of actions would be taken. So one action that can be considered is, in consultation with the construction contractor, the offshore installation contractor, an alternate burial tool can be considered. For example, use of one of the tools that was listed in, for example, table 1-3 of the DEIR, including some kind of jetting device that is feasible for post-installation, further burial. However, if the determination is made that such attempts would not likely succeed, an alternative method for protection of the cable is as listed in the reference section of the FEIR on page 4-3, use of secondary cable protection, what we're calling secondary cable protection being rock and mattresses. Generally, from what we understand of the soil that we expect to see in Mount Hope Bay in the Massachusetts portion of the export cable corridor, the soft sediments that are present would be suitable for jetting with the primary tool method. So we don't believe that there would be an entirely infeasible burial operation, but in the event that successful full target burial is not achieved, that determination would be made in conjunction with the construction contractor, and the details of the specific protocol would be more construction details and specific to the tooling that's employed. So for example, some tooling might have the ability to operate in multiple configurations. Some might only operate in a single configuration, which would then allow more flexibility in a given area. So we don't have the specific protocols, as that would be more construction details that is developed as you get construction contractors on board. But in general, the protocol would be as I've laid out, right? So you would attempt burial using the primary tool that's been assessed, monitor and measure whether that burial has been successfully achieved, comparing against the cable burial risk assessments that have been prepared. And if proper burial hasn't been achieved, then use of either a second burial tool method or secondary cable protection if the second tool method is not believed to result in a chance of success above what the primary tool was used, would be then employed.
So I understand from the CBR, the cable burial risk assessment study that has been completed, the company is confident that the first lay, which includes laying cables with the primary tool methods, at this point seems feasible.
Yes, that is correct, and I think that is not the primary objective of the cable burial risk assessment. As a general statement, the primary objective of a cable burial risk assessment is to determine the required burial depth based on the threats, external threats to the cable, and also just generally seabed conditions. But the assessments of the sediment do suggest that, correct? Yeah. Mm-hmm.
Thank you, Mr. Rai. Now, I am going to reference some confidential material that was submitted by the company, and particularly attachment E and attachment J. The risk assessment, the cable burial risk assessment, and the benthic monitoring studies. I won't touch upon or elaborate on the substance of these attachments, though. So, to the best of the company's ability to answer them, please try to answer them.
Okay.
So at 4.2 of the FEIR, the company mentions that the cable burial risk assessment serves to optimize achieving target burial depths and to mitigate potential conflicts between commercial or recreational fishermen and the new marine infrastructure. The question is, now, does the company foresee any requirement to increase or further optimize the recommended cable burial depth range to lower the risk of exposure or cable damage due to activities including vessel movement and anchoring.
This is Tim Ryer. I'll speak in general terms about the cable burial risk assessment attachment E. We believe it has comprehensively considered external sources of potential interaction with the cable, including anticipated fishing in the region of interest, as well as external emergency anchoring or planned anchoring of vessels.
Thank you. Now, something that alludes to these attachments again. At table 4-2 of the FEIR, the company presents the disturbances expected during seabed preparation and cable laying. Obviously, this information, since it's very crucial for our assessment of impacts in the LUO, I'd further, want to talk about this as well. The company also mentions that these figures were derived from estimates of the percentage of the ECC that may involve these activities. Now, I understand that there are assumptions regarding the ECC route length, the cable burial configuration, and
I'm sorry, the ECC what? Route land?
Route length.
Oh, thank you.
Cable burial configuration and cable burial methods that have been applied to these estimates. Now, given this context, now the CBRA or the burial risk assessment study is done, the benthic monitoring study is done. Do you expect these figures to change in any way at this point?
This is Tim Ryer speaking for the company. No.
Now, can you explain the 50% contingency that has been built to estimate disturbances due to HDD exit pit? This is pages 4-6 and 4-7.
This is Tim Ryer. I do see that contingency. I do not have a specific explanation around it besides the fact that we wish to undertake a conservative approach and analysis in case the size of the HDD exit pit or the surrounding construction impacts were slightly larger than what we had initially anticipated in terms of footprint. So we, given the 30% design level of the facilities, included a contingency level in there just in case the impacts or any sort of side cast material increase those surface impacts beyond what we had estimated.
So I just so I understand, is this like standard? Is that kind of a 50% tolerance built in usually? Because
this is Tim Ryer. I would have to ask to what standard you're referring. We prepared these estimates based on our own engineering, and I don't believe that I would have a reference point to determine whether or not that estimate is standard. I would say in general principles, adding some level of contingency to estimates of environmental impacts based on a preliminary engineering stage would be reasonable engineering practice, but this is just general statement.
Okay. Now, at 4-7 of the FEIR, the company explains that the HDD trajectory on the Lee River side approach is being revisited to avoid impacts to the sheet pile wall. At what point will the company consider any required realignment, a project change for which a separate filing would have to be made?
We are actively undertaking that engineering update to figure out how to maintain adequate separation from the sheet pile wall. Our intent would be to supplement with those new engineering drawings. And at this point in time, I don't believe that the offshore exit pit would really be altered or different spatially from what we've submitted thus far.
Thank you. Now, can you, for the record, state the width of the ECC corridor?
This is Tim Ryer. The approximate width of the export cable corridor in Massachusetts state waters is 700 meters wide. However, I say approximate because in approach to the landfall, the area that's surveyed may be wider or less wide, depending on both the requirements to approach the the site with in approach to the HDD, in addition to potentially being constrained on the width of the the width of the physical ocean space available. So, for example, an approach to the Lee River, I believe there's a certain portion that's narrower than 700 meters, just because the the width from the width of the river at that point is slightly narrower, but it's approximately that width, 700 meters.
I'm just trying to understand. I understand that for cable laying, the company does mention that, the kind of disturbances that would be involved is around 6 meters on either side of the cable route. What is the justification for, having this difference in the cable corridor width? Why did so much of difference have to be built in? Yeah.
Oh, absolutely. I'm happy to cover that. So the export cable corridor is what I would consider to be a study area or a survey area. So we have done geophysical surveys to cover the entirety of that area in order to assess for the seabed condition, any areas of archaeological significance. So that really is a study area. And the intent there is to use that study area for flexibility to route cables to find the least impactful portion of the seabed in order for which to route those cables through. So the width of the corridor does not correspond to width of impacts. It corresponds to really flexibility to microsite to avoid, minimize, mitigate impacts by routing cables in the most suitable, least impactful area of the seabed, and really is conflated to a study area rather than an impact area. So that was the intent. Is we studied a wide area, in order to determine the best place to site the cables and really have comprehensive studies of the seabed in order to, not minimize the area in which we site too early.
Thank you, Mr. Wright. Mr. Shea, at this point, I think we could break for lunch if that's okay.
That sounds good. I'll see you all back here at 2 o'clock. Thank you.
Mr. Shea?
Yes.
Just one moment.
Yeah.
We have a witness on noise or sound that is here, Andrea Wood. I don't know if she'll be needed this afternoon, and if she is not, I'd like to dismiss her, please.
Let me ask my colleagues if they have questions on noise. Ms. Devakar, do you have noise questions?
No, I do not.
Mr. Wong, you don't have any?
Me neither.
Okay, and Mr. Green. All right, so there are no noise questions. I guess you can dismiss her. Thank you, Mr. Runge.
Thank you. We'll see you at 2.
See you at 2.
Jamie, can you go on screen?
Mr. Runge, it seems to me that most of your witnesses are here.
I think that's a good observation. We're ready to go.
Okay, Smitha, are you ready to ask more questions?
Yes, Mr. Chair.
Okay, Alan, let's go back on the record. When we broke for lunch, Smitha Devakar was asking questions, so I'll turn the floor over to you.
Thank you.
Oh, I think you're muted. Smith, I think you're muted.
Can you hear me? It's just that
Now I can hear you. Yes, now fine. Thank you.
Yeah. So there's one more question with regard to the confidential attachments that came to us, after which I would like to move on to water and wetlands. So the question I had was, now in page, this is the confidential attachment that I'm referring to on page 16 of that attachment. There is a reference to carbon trust guidelines. I was just wondering.
I'm sorry, there's a reference to what?
Carbon trust guidelines. Now, I'm not dwelling on the substance of it. I just want to know, who recommends these guidelines to be used in developing the, cable burial risk assessments.
Yeah, absolutely. This is Tim Ryer. I can speak to that. So the Carbon Trust is is an industry body that is based in the UK, and they develop guidelines to which which are considered by many to be industry standard for this sort of assessment. So the method of assessing cable burial risk has evolved over time, and the industry practices generally follow this method. I can't necessarily point to right now a specific standard that recommends this standard, but I'll generally speak to it being the industry standard and generally accepted best practice for cable burial risk assessment methodology, considering the risk factors that we have discussed and are discussed in the document, including external threats and fishing risks interactions.
You wouldn't have any references, right?
I do not have them offhand. I apologize. I don't have offhand any references to a separate standard that recommends that standard, but perhaps that would be something that we could find with more research.
Okay, I'll at this point move on to, thank you, Mr. Wright. So I'll move on to the water and wetlands section. So to begin with, I'd like, just so that, I'm going to, let me say it this way. So I'm going to refer to some parts of the analysis. So I add some context to mitigation that is mentioned in the FPIR. Okay. So Now, based on material on page 5-2 of the analysis, the company identified. Maybe we don't have to get there. I'll just ask you the question. So this is on page 5-2 of the analysis. The company states the proposed onshore transmission system and components will be installed underground, within and beneath pre-existing disturbed areas at the former power plant site. The question is,
I'm sorry, at the former what?
Power plant site.
Power plant?
Thank you.
Sorry.
Thank you.
Yeah. So does this imply that there is no new development?
This is Jamie Duran from Power Engineers. So to answer your question, I believe yes, but I'll just back up. So the cable landfall, as we've discussed in the past, is making landfall via horizontal directional drill. So we'd be going beneath coastal bank. Kelly Smith mentioned earlier the sheet pile wall. Can you still hear me? My computer's okay. The sheet pile wall. And so we be coming up on land within previously disturbed areas on the Brayton Point site, areas that are either currently a paved access road or concrete or other gravel areas that have been used in the past for either staging or there's been past development from the Brayton Point plant in the past. The underground HVDC route will be within the existing perimeter access road along the Brayton Point site. And as well, the HVDC converter station is within areas previously developed over the past decades. So I do not believe there are any new areas that have not been disturbed in the past that will be disturbed as a result of the SouthCoast Wind project. That's the onshore components.
This is Ms. Smith, and I would just emphasize that as well. The entire 300-acre site as a former brownfield it would be considered previously disturbed by the stormwater standards, so would not be considered new development as we understand them.
Okay. So, so is it safe to assume that there are no changes in land cover?
This is Ms. Smith. There are no changes in land cover along the export cable route, whereas Mr. Duran said we would be going under existing access road and restoring that access road or existing surface in kind with how we found it. There would likely be land cover change at the converter station site, so the 10-acre parcel.
So does this change in land cover increase or decrease impervious cover?
I think we'll have to, it really depends on what baseline you take as existing conditions. So it's something that we'll have to continue to develop and probably have that conversation with Mass DEP and with the town of Somerset as part of the NOI. As existing conditions stand right now, there are still some remnants of former lined basins. Those remnants I would consider to be impervious cover. But then Brayton Point LLC will do their own regrading efforts and stormwater analysis. And what they define as proposed conditions in their stormwater model will likely form the basis of our existing conditions for SouthCoast Wind stormwater model. So I would say that it's at that point, it depends what they consider to be their proposed conditions that would dictate whether we'll be proposing a change relative to their conditions.
So we've had this conversation before. So I understand in a way the SouthCoast Wind project site is upstream when you consider the Brayton Point LLC site, right?
Sorry, when you consider the Brayton Point what?
LLC site.
Oh.
Correct.
Correct.
So so therefore my interest in the impervious cover, the amount of impervious cover on the South Coast wind site. Do we have any figures? Yeah.
I might have to look for a specific number in the preliminary modeling analysis that we performed. But in terms of land cover, substations are covered typically with a crushed gravel, and that's what we're proposing as well. And that surface would not be considered impervious. So there would be some impervious surface introduced through our buildings and foundation slabs, but not a substantial amount. I believe we have that figure though provided in our ENF, and I can probably pull it up.
Okay. I'm going to give you some time. Do you want to do it now or? Yeah.
I think I can do it pretty quickly if we can pause for a second.
That's helpful. Yeah, thanks.
And if someone on the South Coast Wind team finds it first, feel free. Okay. So I'm looking at our ENF at page. It's page 27 of the PDF. The number at the bottom of the page is 9. And here we cite that the converter station site will be developed in accordance with Massachusetts stormwater standards. Buildings and concrete foundations are expected to increase impervious cover by approximately 1.5 acres. Impervious cover and stormwater management calculations will be refined during detailed design, taking into account the site redevelopment activities of the landowner.
And do we have an a quantification of what percentage of the site is impervious at present?
Present, I believe that was taken relative to the understanding of what's presently on site. And see if I can find it. Okay, so previously we were not assuming that any portion was impervious, which is probably a little bit conservative as a starting assumption. And we had assumed that the 1.5 acres would be one acre of that would be attributed to buildings. And I believe that included foundations. And then another ½ acre potentially to impervious access roads internal to the site, which may or may not ultimately be paved.
Thank you. So is there any reason to believe that you would have, I would think you would have to work off the existing.
I'm sorry, the sound just cut out for me.
So I was asking Ms. Smith, I believe that they would have to work off the existing impervious cover or the proportion of impervious cover on the site currently when they design their stormwater systems.
Part of the audio cut out for me there, but I would say that I actually think that our base case for existing conditions really is where the Brayton Point LLC grading and stormwater system design leaves off. So that we really should be revisiting our base case from what was presented in the ENF once we understand the size of the best management practice and the grading that Brayton Point LLC will be proposing. So they might make a more conservative assumption about impervious cover as part of their stormwater BMP sizing. And then any incremental and additional work that SouthCoast Wind may have to complete on top of that would be based on where the Brayton Point LLC design leaves off.
Okay.
At least
This
that's how
might-
I've seen it done previously in my work as a water resources engineer when I was a consultant previously.
Okay. Just specific to this context, I understand that in developing the SouthCoast Wind site, you're not going to connect to the MS4. The stormwater system is not going to connect to the MS4, but you are going to connect to one of the discharge points of the Brayton Point LLC stormwater system for the site, right?
Correct. So currently their stormwater for the 10 acres as it sits currently, it drains via surface drainage primarily and some piping to what's called the lower supply basin, which is the remnant of the cooling canal located to the southwest of Brayton Point. You can see the water if you look at an aerial image of the site. And that basin currently is sealed off, so it doesn't actually have its own discharge. However, that area is considered land subject to coastal storm flowage. So that is.
I'm sorry, that area is considered what? Wetlands?
Land subject to land subject to coastal storm flowage.
Thank you.
Okay, I'm trying to understand better. Now, during our earlier discussions, we did mention that, the company did mention that the Brayton Point LLC would have a separate NIPDES permit, right? And the SouthCoast Wind project will have a separate NIPDES permit, right?
Yes, that's my understanding.
Yeah. So my question is, at what point is the performance measured for each of these systems? Now, you did say that there is, a point of discharge to this inland water resource area. At what point is the performance of the SouthCoast Wind stormwater system going to be monitored or measured? Physically, at what point?
This is as if I would say that it would be at the downstream most corner of our converter station parcel. And that outlet of how our system ties into their system has to be engineered based on whether they use surface swale, for example, or whether they ultimately use piping. But that would be it. It would be the downstream end of our site. But the land cover and the impervious cover will be compared. Our proposed conditions will be compared against where they leave off with their modeling and assumptions.
So let me try to understand this. So you will have a point at the end of your stormwater system just before it connects to the common discharge point of the Brayton Point LLC, where the performance standards will be measured. The PSS, the phosphorus, whatever has to be measured gets measured at that point, is what you're saying?
That would be the point. Yes, that would be the point where our system joins up with their system.
So in case, let me ask it straight to you. So in case Brayton Point LLC's stormwater management system does not meet performance standards as per NIPDES, the SouthCoast Wind stormwater system would not have a liability, right? Because you are under two different NIPDES permit and two points at which the performance standards are going to be measured as well.
I think it's a good question. So their stormwater best management practice is going to be designed, their BMP is going to be designed for a larger portion of the site than just the SouthCoast Wind 10-acre parcel. So yes, there is some boundary in the liability where if their system isn't designed properly or doesn't function properly, that's covering a larger acre of the site than just us. So there is, SouthCoast Wind will be held to the requirements of our own permit.
Now, going back to discussion we were having about land cover, does the company have any commitment with regard to increasing vegetation cover on the site? First question is there any kind of replacement of vegetation that is existing? And what are there any commitments with regard to increasing the vegetation cover on the site?
This is Ms. Smith. So right now, there's a bit of a mix of land cover. There's some gravel existing on site. There is some earth with a bit of ad hoc vegetation growth. And then there are the remnants of those basins that are currently present. So there is already some grass present on the site. And we would also look to use some kind of planting or grass in areas that are not occupied actively by the HVDC converter station. And we expect to need about 6 to 8 acres for the converter station, fenced in yard, which will again be primarily gravel and buildings and whatnot. But the rest we would look to stabilize and use some kind of low level vegetation.
Okay.
And I specifically identify like grass as an example and low vegetation because I think we've talked about this in the context of zoning, but due to transmission system requirements, we likely would not look to plant trees or taller vegetation with bigger root systems in the immediate vicinity of our grounding grid and substation fence. That just would not be in line with industry practice.
And this would not be required along the transmission, the HVAC transmission line routes as well?
The transmission line routes will be placed under what's currently existing gravel access roads. So we plan to restore that in kind. And our understanding is that the landowner would plan to continue using those as access roads. So we would not be vegetating those areas.
Now, just for the record, under what land use classification is the SouthCoast Wind project site now?
This is Ms. Smith. I'm not sure if you're thinking of a menu of sort of land use. I guess I'm not sure exactly how the question is meant.
Let me reframe the question. I'm just trying to understand what is the land use zone under which the SouthCoast Wind project site falls?
I'm not sure if I'm not sure if I'm interpreting the question properly, but I would say that currently there's some low-lying vegetation, some open soil, some impervious. Okay, so that's not, I don't think that's what you meant.
So I'm just trying to understand residential, industrial, residential with some kind of industrial allowed. What is the actual, in term, going by the zoning bylaws, what is the land use classification under which the current site falls?
Brayton Point is zoned industrial.
And there has not been any status change in the last 10 years. Am I getting this right?
To my knowledge, no, it's been an industrial site for many decades.
So going back to the discussion we were having on the stormwater system. Now, what are the points of coordination that you foresee with the Brayton Point LLC in terms of designing the stormwater system?
So my understanding currently is that Brayton Point LLC is likely going to make some kind of general assumption about future percent impervious and do some kind of slightly conservative stormwater best management practice system design. South Coast Wind, we will have to understand and have the final versions of their proposed and permitted grading plans, as well as their proposed BMPs. And we will also ultimately have to have some kind of arrangement for access for operation and maintenance, whereby if we are relying on the function of their downstream larger best management practice, we have the ability to access and maintain it if that need were to arise. So there will be quite a few points of interface as the design matures and going through construction and then ultimately operation.
So the Brayton Point LLC has a separate NIPD permit. South Coast Wind has a separate NIPD permit. The South Coast Wind project site is upstream. So therefore, the design of the stormwater system is going to can happen separately, because your performance at the discharge point is going to be assessed separately, right? So I fail to understand, why is it that you need to wait for Brayton Point LLC to finish their stormwater system design, or even the site analysis, for you to recommend your own stormwater system design?
We are not going to be creating a new discharge point. So we are not going to have a new point source discharge. We will be tying into the existing Brayton Point system, which has its own point source discharge to the lower supply basin. So we will need a way for our grading to tie into their grading and our downstream end of our system to tie into their swale or their pipe. So functionally, there will be an engineering tie-in point, and in order to design our upstream system and determine what level of upstream system we need to know where their design is leaving off.
So tell me this, you were mentioning that at the downstream, there is a point at which you will connect to the Brayton Point site, but just before you connect to the Brayton Point discharge point, Now, just before that is where you have your system monitored and measured for performance, right? So until then, so you know what is the amount, what is the level of TSS reduction, what is the level of nitrogen reduction, what are the volumes that need to get to that point, if it has to be contained in the already existing inland water resource area, right? You know the volumes, you know what kind of reductions are expected of you from the NIPD's permit. And you're saying that, the performance measurements are going to happen at a point before the South Coast Wind stormwater system merges into the flows, merge into the Brayton Point flows in the inland. So I still don't understand what is holding off South Coast Wind from advancing its stormwater management system design.
So to that, I would say that the Brayton Point LLC is still determining what level of percent impervious they'll be accounting for in their BMP that is downstream. Some level of conservatism that they factor into that BMP design will likely mitigate the size that our BMP needs to be. So there is also a tie-in for the water quality modeling and the overall accounting. So it has to do with, in the modeling exercise, where we compare pre and post development land uses. Does that help answer the question?
It does. I'm still a bit confused, because I remember we having this conversation where you mentioned that the site drainage direction is largely towards the inland water resource area, right? That's the direction largely, right?
That's the direction. What?
Largely.
Was that in reference to groundwater or stormwater?
I think you did mention groundwater flows when we were talking aquifer, but I think we were talking about side drainage as well, because I remember we mentioning draining into the Lee River side of it, and the flows being largely from the contours, I think it was both ways. So you get my confusion, right? I mean, I know that although this is upstream, the other Brayton Point site is downstream. There is a point at which it still is draining into, which means that it doesn't have to traverse the Brayton Point LLC site. So whatever be the BMPs they are designing, the LIDs they are designing, you still can have your own designs happen because you know what you have to achieve at the discharge point.
So our drainage is all internal to the site. Our stormwater, the way the grading is currently proposed, it would grade to the south and ultimately end up in the lower supply basin, which is not a discharge point to the Lee River, to, I guess, clarify that. So there is a bit of a distinction between the stormwater and the groundwater flows on site. But I see that that's not answering your question. I guess it's just that really that incremental land cover consideration. But if there's maybe a specific question or point of confusion, we could take that away as a record request.
Well, I'm sorry if I'm not clear about it yet. So from the map that was shown of the site, I understand that this inland water resource, which is the basin that you're talking about, right?
The lower supply basin?
Yeah. So it's not all the way down near the Lee River shoreline. Yeah, it is somewhere closer to the South Coast Wind, in the northern part of the site, closer to the South Coast Wind property, right? The lease area.
It runs, the lower supply basin parallels the Lee River.
Yeah, but it doesn't, so flows to the basin do not have to traverse the Brayton Point LLC site.
I'm sorry, could you repeat that last one?
So the flows from the South Coast Wind site, when it moves into this supply basin, it does not have to traverse the rest of the Brayton Point LLC site.
It has to travel across part of the Brayton Point site.
Okay. Okay, that gives me some clarity. Okay. Now, at 4-4 and 4-5 of the FEIR, the company lays out requirements the company intends to meet to submit a water quality certificate. I'm just curious, when does the company propose to submit this water quality certificate application?
This is Kathleen Freeman. We've retained a consultant to prepare a sediment sampling plan. As soon as we have that sediment sampling plan, we anticipate adding that to an application that we have been preparing, and we plan to consult with the Mass DEP. We have been consulting with them all along, but probably in Q3 this year.
Thank you.
We want to complete our MIPA process first.
Now, I know that is on way. So the FEI did mention that is on way. So I just wanted to know.
I'm sorry, I didn't understand you.
So there is the FEIR mentions that the sampling analysis, right? That's how you call it, right? Is on way, and you're working with Mass DEP.
Yes.
Yeah, I get it. So I understood that exercise is being conducted so that you can put in this application for your water quality certification, right?
Correct.
So that's why I asked as to what is the timeline that you are chasing in terms of applying for it. Yes. I'm just trying to see.
Kathleen, I should mention that no state permits in Massachusetts can issue until you've completed the MEPA process, which advises the permit writers on what are the impacts, what mitigation would be appropriate to write into the permits. So we hope to complete the MEPA process in September and get a certificate in September. And again, we hope to have a draft sediment sampling plan ready by then.
Thank you. Now, in some parts of the FEIR, I can quote if required, but my question is this. So in some parts, I read that the Brayton Point site has an existing stormwater system, but in some parts, especially in the FEI attachment D of the FEIR, I read that the company.
I'm sorry, especially in the what?
Especially at attachment D of the FEIR. The company states that the project site will discharge stormwater to the collection system being designed by the landowner. So currently, is there a stormwater system that Brayton Point site has? And if yes, do you have any details regarding that?
Yes, this is Ms. Smith. They do have stormwater infrastructure in place currently. I think there is a manhole for drainage to the northeast end of our site, and our preliminary grading plan, which we submitted with the analysis, shows a tie-in for a stormwater BMP to that system. So the intent of our indicative grading plan was to show that we can accommodate a stormwater BMP, a line stormwater BMP that can contain runoff from a 100-year storm event and then tie in off-site to the Brayton Point system. However, Brayton Point LLC is continuing to engineer their grading and stormwater system improvements. And as of the latest in progress iteration, I think they are planning to use surface swales instead of that existing drainage pipe system. And I think they're planning to install some kind of a sand filter or other BMP directly to the north of the lower supply basin. So there are significant enough changes underway with the grading and drainage that it is important that we tie into their proposed conditions. So we do have information and we are continuing to coordinate on it, but until it's through its own design, its own review process, and its own permitting process, we won't know exactly how we're going to get the site.
Thank you. Now at 4.4-7 of the FEIR, there is a sentence, I'll just read it to you. As indicated in the Massachusetts Stormwater Handbook, Volume 1, Chapter 1, SouthCoast Wind anticipates requesting a waiver for peak rate attenuation and volume control requirements.
I'm sorry, a waiver for what?
Waiver for peak rate attenuation and volume control requirements. Now, I had a question just so I understand this better. Does this imply that the post-development peak discharges could exceed pre-development discharges?
This is Ms. Smith. The reason the waiver box was checked is because the discharge point for the system would be to the lower supply basin, which is land subject to coastal storm flowage. And because of that, I think the standards are written in such a way that they contemplate the fact that for tidal water bodies, it's really the tidal characteristics that are driving flow in those surface waters. And therefore, it's not the same marker of water quality or not the same environmental consideration as you would see for an inland freshwater water body. And therefore, the peak flow attenuation criteria is not as pertinent.
basically means it interpreted different. It just means that even if pre-development discharges are high, post-development discharges are higher, it shouldn't matter.
That's the essence of my understanding of the criteria and why the waiver is a possibility.
Okay.
We may still find that through detailed design, post-development runoff rates are lower than pre-development runoff rates, but I guess that's not necessarily known at this time, and it's maybe not as relevant, which is why the opportunity for the waiver exists, given the fact that it's a coastal resource.
Just wanted to know that doesn't call for a commitment in terms of reducing runoff flows, right? That's all I want. Yeah.
And I do want to note, not to make this a more confusing topic, but unfortunately, in preparing for the hearing today and re-reviewing the FEIR, I did catch some language in section 2.4.1 of the FEIR, which is a little bit confusing when reviewed relative to the language in section 4. And I did just want to clarify that we'll continue to work with MIPA on that, but the language in section 4, which is what we've been talking about so far today, that supersedes what was in 2.4.1. I think there's just a little bit of misalignment in how it's worded, and so if we could disregard 2.4.1 for today, that would be appreciated.
Thank you. That helps clarify certain things. Now, in the same attachment D, there is a mention of preliminary groundwater review, which likely indicates no cause of concern about groundwater recharge through infiltration on the project site, even with the AUL in its proximity. Now, does the company have details of this groundwater review? And if it does know what the content is, if you could share what the findings on this groundwater review have been.
This is Ms. Smith again. Would you mind repeating the page reference?
We don't have the close to four
the section.
Just a moment. I'm sorry, I didn't hear. We don't have what?
It should be close to 4-7, page 4-7 of attachment D.
Attachment B as in Bob.
B as in dog.
Okay.
I just want to have understand more details about this groundwater review that you're talking of here.
Sorry, just I'm reading the passage and then I'll respond. This is Ms. Smith again. So at this time, SouthCoast Wind has completed a phase 1 and a phase 2 environmental site assessment. And as part of that environmental site assessment, we did also look at groundwater levels present on the site. I believe that's what this statement may be in reference to, but I think as the project team also acknowledges that given the proximity of the site to the existing activity use limitation, whether or not a best management practice that we design, whether or not that should aim to recharge or whether that should be lined with an under drain, I think it's still something that we'll seek to consult with Mass DEP to understand.
Thank you. Now we had this discussion on shoreline protection structures, like coastal engineering structures, and how you were trying to not build anymore, but not to disturb what is existing as well. So I'm interested in understanding any collaboration that the South Coast Wind may have with the Brayton Point LLC to cover liabilities and develop mitigation measures so that the safety of the shoreline is ensured.
At this point in time, due to the nature of our horizontal directional drilling installation activities, the project really isn't seeking to modify the coastline or change its armoring. So at this point in time, there have been no collaborative discussions about further reinforcing the shoreline. We're not aware of whether there's a need to do that for the sake of future tenants. That would be something that sits with the landowner.
Now, the site assessment reports that you were referring to are the ones that you have submitted as attachments to the FAR, right? I mean, as record request, EFSB 3212, part 1, part 2.
Yes.
I have a question on visual impact mitigation, because I haven't found any follow-up in the FEIR, so I'm going to base my question of the analysis. Now, at page 4-1 of attachment H of the analysis, you don't you can refer to it, but I'll just state what the content is here. There are mitigation measures that the company has proposed for visual impact. Now,
I'm sorry, for what?
Visual impact.
Racial?
Visual.
Oh, thank you.
Is it to be understood that the 7-point measure that the company has mentioned there is the company's current commitment to visual impact mitigation? I can restate the page number if you want.
Yes, please.
Page is 4-1 of attachment H of the analysis.
Almost there. Apologies.
Oh, no problem. Take your time, please. This happens to be my last question for the day.
Okay.
So there are, 7 bullet points mentioned, and the mitigation measures are mentioned there. Currently, is that the commitment that a company makes towards, mitigating visual impacts?
This is Ms. Smith. Yes, that remains a list of proposed mitigations.
I'm curious, what are the components of the converter station that the company proposes to house inside the building?
The main converter station equipment will be located in what might be referred to as a reactor hall or a valve hall. And that's where the key conversion from DC to AC occurs. We also anticipate having a storage and maintenance building on site, as well as a control house where the electrical control equipment is located. So there will be some component converter station that are inside, but we also expect to have some of the electrical equipment located in an air insulated yard, so outside of buildings.
Okay, thank you very much. Those are the questions that I had. Mr. Shea, if there's anyone else who has questions, I think Mr. Wang has questions.
So you think who has questions?
Mr. Wang?
Mr. Wang.
Andy, do you want me to go ahead first or do you want to go first? Okay, thank you. Thank you, Ms. Devakar. I have just a few questions following up on the hearings and throughout the weeks. The first one is from this morning. Mr. Rund, you had referenced a record request. I believe you said RR-EFSB-17, which linked to a recording of a zoning board meeting. Do you recall that?
I do.
I tried to look that up and I'm not sure that that's the right number. Could you, could I give you this task and you can tell me later if you find the right number, or maybe I'm looking at the wrong record request.
Mr. Wang, let me just say that on Friday, we submitted a supplemental filing to EFSB-17, where we provided at the, if you go to the end of that document, you'll see something that says supplemental response. And under that, there is a link to the zoning board meeting that occurred on April 20th. It's a YouTube meeting, I believe.
Thank you.
Can I add to that?
I'm sorry, who's speaking?
This is Attorney Pucci.
Oh, thank you.
Just so you don't watch the whole thing. I mean, you can watch the whole thing if you want, but the SouthCoast Wind discussion is toward the end of the meeting at 2:32 into the meeting. Like 2 hours and 32 minutes into the meeting. So I'm sure that the link that the project proponent provided is probably the same link I have, but I just wanted to note that so you weren't watching the entire thing.
That's helpful. That could be painful to do. I would just say that in our narrative supplemental response, we do actually target that same time frame that Mr. Pucci just mentioned at 2:32, and then there's something at 2:45 that is of interest, I would say.
Thank you, Mr. Wrench, and thank you, Mr. Pucci. That's really helpful. Okay. So following up on my cross-examining of the town's witnesses on, I guess, a few weeks ago, I had questions to the town witnesses, to one of the town witnesses about the changed nature of Route 79 in town. Does that ring a bell to the witnesses, to the company witnesses? So I'll just ask. Sorry,
Jamie.
I'm sorry, I didn't hear what you said, Mr. Dorian.
Yeah, I said yes. I was confirming Mr. Wong's statement about, we had a discussion about work that was happening on State Route 79 in Fall River.
Thank you, Mr. Duran. So I just wanted a confirmation from yourself or any other witness that any traffic studies that you have conducted have taken into account the changed nature of that route. From what I understood, it takes it's turned from a larger throughway into a smaller one.
So currently, my understanding is they're looking at both State Route 79. I think 24 is in that location. So right now, most of that section of 79 is actually been removed, is what's happened. In regards to the the traffic study report. I think that's something I will need to look at if we considered the elimination of that section of 79, and improvements being done to date. Unless Kaylee, unless you recall if the traffic report included that 79 work.
This is Ms. Smith. For the traffic analysis report, we did consider some of the recommended routing that we'd previously heard from the town to avoid a particular turn from 195. I don't know that the numerical data that was pointed to was collected after the Route 79 closure. It might have been collected beforehand. So yes,
Thank you.
I guess we would be happy to take a record request if there's.
Thank you. I appreciate the answers, and I would appreciate you confirming that and rewriting the numbers if needed.
This is Jamie Duran from Power again. I'm sorry to interrupt you. I'm just currently just reaching out to one of our traffic engineers to see if he can confirm that statement or not, what information we can use for State Route 79. So hopefully I'll have a response back to you shortly.
Sorry, our internet, even on cable here, is not doing so well. So from what I understand, Mr. Duran, you're just going to confirm, and if needed, we'll do it.
I'm sorry, you dropped out. Wayne, you dropped out.
Yeah, I'm on.
Mr. Wong, this is Jamie Duran from Power. If you can hear me better, yes, I'm reaching out to one of our traffic engineers as we're speaking to see if he can provide the information about State Route 79. If he does not respond timely, then we may request a record request. So if you could maybe just give me a little bit if you ask your other questions, and I'll see if he responds. Does that work?
Yes, thank you. Another question that I had for the town, or rather the town brought up, was the initial, and I understand this isn't the current design of the company. The initial, at some point, the town was presented with an idea for the converter station to be within a building. Does that sound familiar to the witnesses today?
Yeah, this is Jamie Duran from Power. I think we indicated that the HVDC converter station we have now will be in a building, and I think there was some discussion about something that had been presented by others originally on Barak originally.
Yes, I believe there was some discussion about a Sydney Opera House-esque building.
Yes.
So the difference between that conceptual, and I understand that that was not the company putting forward, and that's a different company. But from my understanding, that conceptual design would have had every component within a building, and the current company's design, rather your design, has certain components in a building and certain components outside of the building. Is that correct?
That's correct. This is Ms. Smith.
Thank you. So for the record, just so I can understand sort of a comparison of the two, would you be able to give me a ballpark figure of, the additional cost of having everything in a building, if that was possible even? Because I understand the AIS design necessitates, air. So I wonder if there is a comparison in terms of cost that you could provide, even if it's a rough estimate.
We can certainly take that away and see if there's something we could provide in a timely fashion.
Thank you. I'd appreciate that. It helps me to understand and compare, what's being asked and what's being proposed.
Should we make this a record request?
Yes, please.
Okay. RR-EFSB. I'm going to ask Mr. Brock for the correct number.
It's 39.
39. Okay, do you understand what's being requested of you?
I believe so. I can try and repeat it back.
I'm
I'd
sorry?
like to hear it repeated. Eric Runge for the company. I would like to hear it repeated exactly what we're looking for here.
Okay, Mr. Wong, just repeat exactly what you'd like.
I would like an estimate of the cost for a inverter station design that has all components within a building. I guess the estimate and cost would be in terms of, would be a comparative cost, not like the actual cost, but like how much more or how much less it could be than what the current proposed design is, just so I can get a feel of that.
Okay, and just Eric Runge again for the company, just to clarify, you're talking about a high level conceptual incremental cost estimate for this design that houses all of the components of the converter station, correct?
Correct.
And to the extent that it's comparing that incremental cost against existing cost estimates, some of that, of course, would be confidential, just so we're clear on that.
Mr. Runge, are you saying the incremental costs would be confidential as well?
No, I don't think the conceptual level incremental cost would be, but I think to the extent you're looking for any base information about costs that we've submitted already for the project, those are confidential.
Yeah, I think I will, since we already have that on the record, all I need is the incremental cost.
Okay, thank you.
Thank you.
Excuse me, Mr. Wong, are you interested in also getting an evaluation of the difference in environmental impacts if more of the equipment were included within the building?
I'm not, Mr. Green, would you like that information?
Yes, actually.
Okay.
Do we make that a separate record request or
Could we add?
Just a part B, I think, of this record request that Mr. Wong asked.
Okay, part B would be the environmental impacts of enclosing everything in a converter station.
Not everything, just the additional equipment that was requested in Mr. Wong's question. And again, this is compared to the original proposal of the company. So, for example, we might be, hearing that there's some difference in noise or perhaps magnetic fields or some other related impacts.
Okay, so that would be part of record request RR-EFSB-39 also.
And let me just make sure that the company understands what it is I'm adding on to this.
Eric Runge for the company, just asking the witnesses here, do you understand that request and the scope of it? Anybody doesn't? So I'm going to say on that one, Mr. Green, we're happy to try to do that. I think it might end up being that is going to take more than 7 days to respond to that, but I'll have to consult with the client afterwards.
I think we're waiting on another record request, so I don't think that would be a problem.
Okay.
Thank you, Mr. Green. So, I need to clarify, just a clarification on the terms unviable and uneconomic. The company uses this in their description of, I think, project.
You're dropping out, Wayne.
Under
Wayne, you've dropped out.
The power purchase agreements.
Wayne, you dropped.
Be,
Wayne, you're going to need to start over.
Can you hear me now?
Yes, for the moment.
I apologize on behalf of the Commonwealth and its internet. I'll repeat from the start. So, the company uses the term unviable and uneconomic, I believe, at various places to describe the project as proposed and the power purchase agreements. I just wanted some clarity on whether these terms are used interchangeably or if they meant different things to the company.
Mr. Wang, Eric Runge for the company. I can probably answer that since I drafted a lot of the stuff where those terms are used. I think uneconomic is used specifically with regard to the PPAs, and it involves the economic analysis of those contracts and the revenues anticipated under them compared to costs. And that's the use of the term uneconomic with respect to PPAs. Regarding viability, that looks at a whole host of factors for the project overall. And the viability of the project is impacted by PPAs, but also by many other things. And we've listed a bunch of indicators of progress that show project viability is strong for this project, even though the current PPAs are not economic and will be are anticipated to be terminated.
Thank you. I think that's pretty clear. And just to go back to the questions we have for the town witnesses, I believe one of the town witnesses described, in his opinion, how easy it was to access the Brainpoint LLC site in general. I'm wondering what the company's plans are, and maybe this is described in the petition or somewhere else, and let me know if it is, what the company's plans are in terms of site access security and how that would be managed come operation if this project is approved.
This is Ms. Smith for the company. At present, there is what's called the guard shack, which is at the southern end of Brayton Point Road, and that is a manned and fenced-in access point. Further north on the site, there's currently a fenced-off access road, that's where we would propose to access our site during operations. That fence is daisy-chained shut from access, and I believe National Grid has a key and some of the other entities on site have a key. But I do acknowledge that it would be possible for someone who wanted to trespass to walk around that entry point. During operations for our facility, the internal converter station site will be fenced off and have protections in line with industry standards, including cybersecurity and other access considerations, in line with what National Grid does for their substations. And so I guess despite the fact that there is a potential that someone could, when there's a way in terms of trespassing, I do believe there has been sufficient security in place for the National Grid assets, and we would look to do something similar for our utility scale assets.
Thank you, Ms. Smith.
And I would also say that during the construction phase, there would be additional site presence and additional security for any open works.
Thank you. Mr. Durand, has your colleague gone back to you yet?
This is Jamie Durand from Power. I'm checking right now. No, I did not receive a response from him regarding State Route 79, so perhaps we take this as a record request and we can track down the information for you.
I would appreciate that.
Okay, Mr. Wong, could I ask you to just repeat exactly what you want in the record request?
Okay, the request broadly is asking for a confirmation on whether the company's traffic studies took into account the closure of many lanes for State Route 79, and if not, whether the company should, no, sorry, if not, could the company conduct a new analysis or refresh its analysis based off of that new information.
Okay, and that'd be record request RR-EFSB-40.
I have 41 for that, I think.
I'm sorry, let me, let's go off the record. Alan? What is it 40 or 41? Because I think the last one that you told me was 39.
40. 39 had two parts.
Oh, it's part
Yeah, this is 40.
This is 40. 39 had two parts, right? It wasn't 39 or 40. It was just a two-part question. So this is 40.
Yes.
All right. So let's go back on the record. This is RR-EFSB-40.
Do you hear us in the hearing room?
I can hear you.
Okay, I am done for now. I guess, Mr. Green, if you have questions, could you ask them?
Sure.
Thank you.
Okay. So this is a very general question. I'm not sure if it's answered by either the petition or any of the other materials, but I'm looking for an opinion on the general question of whether, in comparing the no build option, which is to leave the SouthCoast site essentially as is, versus constructing the project, whether the environmental impacts of the operational phase of the project would be greater than or less than the existing environmental impacts of the site as is, if that can be answered.
Eric Runge for the company. I'll just start. I think in the petition, Mr. Green, I'm not sure if it was in that section that dealt with alternatives, including the no build, but it may have been in there. In any case, the company does point out the benefits that the project will bring, the environmental benefits, particularly reductions in greenhouse gas emissions, very large, substantial amount of those. So I think that is in there. I just don't know exactly where in the petition it is or in the analysis, but I'm pretty sure it's in that section that you referenced.
I do recall that, Mr. Runge, and I think I should have been more specific in clarifying that I'm really looking for a sort of narrower assessment of impacts in terms of looking at what's happening on the site under the two scenarios in terms of local environmental impacts, not so much the global impacts of carbon reduction.
I'll just, Eric Runge again, I'll just look for the fact witnesses if they want to pick up here, but I think there was also discussion in the petition and the analysis regarding benefits to changing the Brayton Point site generally into a clean energy hub that is intended by the Commonwealth and by state policies. So I think that was discussed in the petition. And that's more localized.
I suppose to that, I would just add that the Brayton Point site has a lot of potential for redevelopment to support renewable energy development. So I think if not South Coast Wind, there would be some kind of proposed project that would ultimately come along to use the facility. And during operations, it will be an unmanned converter station. And so there won't be any operational impacts to traffic, and we will comply with the noise bylaws. So I do think that by dedicating a 10-acre section of the larger site to this proposed South Coast Wind project, I would consider it to be a net positive.
So, Ms. Smith, if you were, let's say, one of the closer abutters in the community to the project location, do you think that the abutter would perceive and have reason to perceive greater environmental impacts or fewer impacts in the operational phase of South Coast Wind relative to, again, the existing site as is?
I guess this is Ms. Smith again. It's hard to slice and dice because it is such a large industrial site and other corners of the site are being used for other activities. But I would say, if you were to say compare to the notion of staging and moving scrap metal from that portion of the site to the wharf to be shipped off, relative to that sort of a use, it would be considered less of an impact if I were in a butter.
Yeah, I think the record fully supports that statement, but the scrap metal operation is no longer, correct? That's been discontinued?
That's correct. I guess I cite that as an example of other industrial uses that could otherwise use the parcel.
Mm-hmm. Okay, all right, I think we can probably leave that question as is then. And then turning towards the economic question and viability and so forth, economic viability. I think we may have had some discussion on the record previously, but I think it's known through the media that Rhode Island conducted a solicitation not very long ago for offshore wind that resulted in Revolution Wind 2 being considered as a offshore bidder. Is the panel familiar with that situation?
Yes. This is Jennifer Flood. Yes.
Okay. And it's been, again, reported in the media that Rhode Island, and I think the potential off-taker, Rhode Island Energy, has decided in consultation with state officials to decline the offer due to the cost in particular of Revolution Wind 2. Again, does that comport with your understanding of recent events?
Yes.
So that obviously every project has unique economics and every state has its own set of requirements and state procurement objectives. But I'm looking for an opinion from the panel as to whether that experience in Rhode Island should give pause to the notion that if a project is built, a contract will develop from that project. Is there any potential that the situation that happened with Revolution Wind 2 could be the new normal or replicated, that state procurement procedures are just simply not prepared to pay the price that developers need to build these projects?
Eric Runge for the company. Just I can start on this and then turn to the fact witnesses, but I do know that no company will ever start a project being built without a contract in place and without major permits in hand. That will never happen. And then two, yes, there are cost increases and they have been reflected in that situation down in Rhode Island. And that's one of the reasons why South Coast Wind is terminating its PPAs, but the region has called for offshore wind to be a cornerstone of its energy supply for the next several decades. And that's simply not going to happen if we can't work through the cost issues, I would say. And anybody else can pick up on that.
This is Ms. Smith. I guess just to that, I would add that ultimately what came to pass with the Revolution Wind 2 project example is that they were the sole bidder. So one could make the case that it would be then difficult to for Rhode Island to turn around and say that that was a compelling and competitive enough project to move forward with procuring without another project to compare against. So I would not necessarily consider that to be a trend.
Okay, thank you. I have no further questions, Mr. Shea.
Very good. Mr. Runge, do you have any redirect? No. Yes, redirect.
No, I do not.
Mr. Pucci, do you have any questions?
No, thank you.
Okay, if no one objects, it's time to wrap things up. First, I would say let's I have to move all exhibits that have been marked for identification into the record. Now, this will be obviously with reservations. There are pending rulings on motion for protective treatment, and I gave a ruling this morning on the Zoning Board of Appeals letter. But pending the rulings on on protective treatment, I'm going to move that all exhibits marked for identification be admitted into the record. Does anyone object? Hearing no objections, the motion is allowed. Now, let's talk about the briefing dates. I think that we're going to get a response from the town to two questions, two record requests on August 25th. And let me get, what we normally do is we don't ask anyone to brief without the full record in front of them. So we normally set our briefing dates off the last documents we received. What would be a realistic time, asking Mr. Runge, what would be a realistic time to expect to receive the reply to the company's list of conditions?
Well, I think we're going to get that on the 25th. I think at this point, it would be less than 2 weeks after that. I think we would strive to do that. I do note that Labor Day weekend falls within that time period, so I would have to check with the client about availability of people. But we're going to strive to move forward quickly on that. If we can do it in the 7 days, we will. I just can't commit right now to do that. And Mr. Shea, I would also note that we have two other things. One is that we have a record request having to do with sound wall and noise mitigation that I think we said we couldn't have a response to until late August, early September. And I see Kelly is there, and maybe she could give me an update as to when that would be coming in.
This is Ms. Smith. I don't have a precise delivery date handy. I apologize, juggling in and out of vacation, but I do think it's a few weeks out. So perhaps ambitiously late August, but it might follow shortly thereafter.
And then, so we have that one, and then we have Mr. Green's request related to incremental environmental impacts that also could take a couple of weeks, but that should be within the time frame we're already talking about. So I don't know if it's your intent to wait and have briefing 3 weeks after that sound wall mitigation record request comes in, let's say, early September, if
Yes.
that is the case. Okay, well, that sounds fine, but I will also note that there are two other record requests out there that are not, that do not have a definite time by which we could respond to them. As you know, one has to do with providing the ground lease when executed, which I think might be this year, but I can't guarantee that. And there was one other that doesn't come to mind right at the moment, but it was the kind of thing that was indefinite, more indefinite than that one, that would be, you know, some distant time in the future.
I don't think we need to wait till you produce the ground. I'm glad you brought that issue up. I don't think we need to wait till you produce the ground lease. I doubt it will have a tremendous effect. If it does, then if it's a you know, a very important piece of evidence, then people can always ask for a supplemental briefing, and that would be fine. But so I don't think we need to. I do understand your position. We have two options. We could just wait until we receive everything except the ground lease, and then I'll schedule initial briefs and reply briefs off of that day. Or we could estimate now.
Yeah.
But my fear is if we estimate now and then the responses don't materialize when expected, it might be inconvenient for people.
Right. And Mr. Shea, I just want to be clear again, there's one other record request that's of an indefinite nature, and maybe Ms. Zepiel has that one handy that she can identify for you, but it's along the lines of, you know, indefinite in time in terms of when it would be submitted. So I would want to also exclude that one along with the ground lease.
Eric, this is the other one that was open-ended was the public benefit determination. And I believe I've just heard that that will be in mid-September. So that one might not be as open-ended.
Okay. The public benefit determination. Let's go off the record for a second. What would people prefer? Would they prefer to get some hard deadlines now, or wait until we get everything except the two items we just discussed, and then get a series of deadlines?
Speaking for the company, I think we would be fine with having, you know, a more flexible schedule as long as there's not, you know, further delay unnecessarily. If we can just exclude those two that are indefinite in nature, and once you get the other ones in, then set the, you know, 3 weeks out deadline for briefing, that would be fine. Okay.
Mr. Pucci, how do you feel?
Yeah, I feel fine with that. But what are we contemplating now because I did want to, I like to have something on my calendar, just to remind me. Because if we're saying the 25th for my extended deadline, and then 7 days or whatever they need to reply to that, are we talking 3 weeks out from that, or was there another thing we were waiting on?
There was one other thing, Mr. Pucci, and that had to do with noise mitigation and an analysis that's being done by the company that might not come in until early September. So I think it would be 3 weeks out from that early September time.
Yeah, if we made an estimate, I don't object to scheduling the 3 weeks out from that. Like if we said that was going to come in, it would be, I would think that would be a good milestone. Use that one as the one to count out from. And then the other two are indefinite. And then if somebody needs to brief after those, they can file a motion. So I'm thinking if we do the 3 weeks out from that anticipated sound wall analysis.
Okay, so let's say, to be on the safe side, that we get the noise mitigation analysis by September 11th. That's a Monday, so Monday after Labor Day. Then we would schedule a brief for 3 weeks from then. Is that that seems to be the best we can do at this point? Is that acceptable to people?
Yeah, we'd be looking at October 2.
Yeah. All right, why don't we go back on the record? Off the record, we had a discussion about the best time for setting briefs and reply briefs. As I explained, our custom of the siting board is not to ask people to file a brief until all the information has been provided. As Mr. Runge pointed out, there's some information that is some information that will be provided, but it's hard to tell when. One would be the ground lease when it's executed, and the other would be the public benefits determination, which would be made by the Secretary of EEA. So those two are excluded. We don't need to, if anyone wants to, when those two answers to record requests come in, if anyone wants to write a supplemental brief, just file a motion. I don't think it should be a big deal. We talked about the various other record requests that were responses that were out there and determined that to be on the safe side, we could assume that we would receive everything by September 11th. So that's what we will assume. If things go badly awry, anyone can file a motion, and I'll be glad to listen to what you're thinking or your reasons. So that would mean first briefs, initial briefs would be due October 2nd. And reply briefs would be due 2 weeks later, October 16th. All right, and the record reflect that all the exhibits that have been marked for identification purposes have been moved into evidence, subject to the decisions on motions for protective treatment. Does anyone have anything else that, before we close the hearing and go off the record, does anyone have anything else they want to raise?
I did just have a question about the motion to stay. My only question would be, is the siting board anticipating us arguing that in the post-hearing briefs, or is there a possibility of a ruling on that in the meantime? Or are you not able to answer that? It's been under advisement.
Yeah, it's under advisement. I think the motion for stay was pretty well briefed already. I don't know that I guess there's no page limit to the briefs in our cases. If you wanted to add something in your brief on the motion to stay, I don't think it would be it wouldn't be out of order. But
I'm not interested in trying to add pages to the
okay.
already voluminous motion filing. I just wanted to maybe get more of a sense of when and if that would be ruled on. Like,
it's good that you brought it up, because I believe you said at one point, now I'm just talking from memory, but I believe someone said it's a motion to stay, but to stay until when? And I believe you said something about January of next year wouldn't be a bad time to stay until.
Yes, I still think that.
Okay, I don't think we need any more briefing on it, and I don't know. It's a big decision. A lot of people will have to weigh in on it, so I don't know when we'll get a ruling on that. I certainly can't issue a ruling on it myself. I'd really have a lot of people have to consult on this, and I don't know. It might even have to go before the whole board. All I can say is that the matter is under advisement, and we will have a ruling, whether it's in the final decision or separately. I can't say at this point.
Okay, if there's no ruling before, I'm not going to repeat the arguments, but I will raise the issue in my brief.
Okay.
In a small section, just to maybe remind that issue is still out there.
Thank you. I appreciate that. Does anyone else have anything they want to address?
Mr. Stay,
yes.
I just want to thank the witnesses and the town witnesses for their time, and also I know Ms. Smith is on vacation, so I appreciate the time taken to talk with us.
Oh, Ms. Smith, I'm so sorry we intruded on your vacation.
No problem at all. Thank you.
That's very regrettable. And it does show a lot of dedication to show up to interrupt your vacation to show up, and we do all very much appreciate that. Yes, I was going to say the same thing. Thank you all for being here, and thank you for being so well prepared. With that,
Mr. Shea,
yes.
Mr. Shea, Eric Runge for the company. May I just say on behalf of the company, we appreciate all the time that the siting board has put into this, staff and the town. So thank you all.
Thank you, Mr. Runge. Yeah.
Yeah, I repeat that as well. We very much appreciate the full hearing. All the witnesses are very appreciative of the way they were treated and the receptiveness to their testimony, and it's much appreciated. Thank you.
Thank you, Mr. Pucci. All right, we are concluded. The hearings in this case are, the evidentiary hearings are concluded, and we're off the record.
All right. Thank
We
you.
used to say
Bye-bye.
good night and good luck. Who it was? It was one of the guys on TV news. Used to say good night and good luck. Anyway. Edward R. Murrow. That's right.
There we go. Yeah.
Mr. Mastoni, that's the right answer. Edward R. Murrow. Good night and good luck. Well, it's not nighttime yet, but thank you very much. We'll see you at some other time.
Bye-bye.
Thank you.
Bye now.